Item for pronouncement of judgment. Item 1, criminal appeal, J 115 of 2018.
Appeal allowed. Impugn judgment and order set aside and plus.
Obliged. May I read your lordship?
Yes.
I'm praying for listing one MHA appeal of 2020.
When?
Now, as your lordship convenient next Thursday.
Correct.
Thursday. Not Thursday, so many cases on Thursday, on 13th, Friday.
Friday. Madam.
That is lordship. I'm prepared for listing a transfer petition, which is leftover of last Friday lordship. Next date in the.
When do you want?
11 lordship. Next date is fixed on 13 lordship. Obliged lordship.
May I please your lordship? Lordship, one MSc appeal, your lordship. Delay has already been condoned. Lordship, that matter may be come up for Lok Adalat on 14th of September, your lordship.
You go and file a petition before the register.
Lordship.
Why direction of the court is necessary?
Lordship, actually, the list has already come out for the Lok Adalat. Actually.
At you. You can approach the register.
Obliged.
May I prevail? In two MSc appeals filed by the insurance company, we are for the claimants. We have filed two interrogatory application for withdrawal of the amount deposited by the insurance company.
When?
Can it be on 13th of life?
Lordship, I beg to mention for listing lordship MSc appeal for orders any date lordship next week.
On
As per
18th,
18th.
18th September.
Okay.
I'm praying for listing of a miss case, your lordship. On
When?
11th. On 11th, your lordship.
11 possible.
There's an execution.
My friend, lordship, listing lordship, MAT lordship.
When?
11 or 13 lordship.
11 already. On
For
18th.
orders. 13.
Possible. Okay.
Right. May please your lordship, I beg to mention item number 80.
1-8.
Yes.
When do you want?
Pass over the matter for today only.
Pardon?
18, no, 18. Next.
Yes. You inform the other side.
Yes.
Who is put in? You. Any objection? As agreed by learned advocates of both sides, let's list the matter on when?
After 1 week.
After 1 minute. Okay.
1 minute.
May I
Yes.
please lordship? I beg to mention two IAs for listing, my lord, on Thursday. These are for IA for withdrawal, my lord, under orders column on probably Thursday, my lord. Deeply obliged, my lord.
My lord, I beg to mention two MFAs of 2019. All of them has not been listed in last 4 to 5 years, my lord.
When?
My lord, September 3rd week.
Okay.
Much obliged, my lord. My lord, there is another MFA of 2013. The matter was listed on 5 September, but matter did not reach before the court, was unable to reach. So, my lord, any date may be granted.
25th.
Take a date from him.
25th September.
Much obliged.
Yeah, please, lordship. I beg to mention for listing of a MSc appeal for orders.
When?
On 25th. 25th September. Items from daily list, promotion bail application, item number 2.
May I please, your lordship?
My lord, it is a very.
Mr. Talukdar, this is third application.
Yes, I understand.
So what is the ground?
Yes, in fact, my lord, your lordship in para A, your lordship has stated that in terms of, my lord, two judgments of the Supreme Court, the subsequent bail application is not maintainable. I understand, my lord. In fact, what has happened, I have gone through these two judgments, my lord. In respect of Papu Yadav and, my lord, the state of Tamil Nadu versus S.A. Raja. my lord, in fact, I want to distinguish, my lord, the facts of those two cases with the present one. What has happened, your lordship is aware, in those two cases, Supreme Court earlier, my lord, what happened, my lord? Initially, High Court granted the bail. Then SLP, my lord, in SLP, that judgment, my lord, was challenged. In SLP, my lord, honorable
Maybe facts may be different from case
No,
to
my lord,
case.
the law has
But the
been laid down.
principle
if
of
I-
law, whether those principles are applicable here in this case
Yes.
or not, that is
No,
the question.
Absolutely, my lord. The law has been laid down. What the
Mm.
Honorable Supreme Court says,
Mm.
well, the facts will also come in.
Mm.
Because once, my lord, the bail application having been, my lord, rejected by the Supreme Court,
Mm.
my lord, the Honorable Supreme Court says, subsequently, High Court cannot grant.
No, you
That,
tell
my lord,
me,
ground is
now,
accepted.
now you tell me what is the change of circumstance in
No,
your favor?
Lordship will kindly see, my lord, what I'm trying to say. My lord, what the Supreme Court says,
Mm.
there should be a findings of the High Court
Mm.
that there is a prima facie case
Mm.
that the accused is involved in the offense.
Mm.
Then only, my lord, the changed circumstances
No,
will come into
now,
play.
now do you want to submit that there is no prima facie case against you?
No, what the Supreme Court says, the
Mm.
Honorable High Court should record, my lord, in the bail application
Mm.
that there is a prima facie case against the accused, my lord. Therefore, the bail application is rejected. Now, what I find, my lord, from the Honorable Court's, my lord, order, in two orders, your lordship had rejected the bail application on the ground of gravity of the offense, my lord. If your lordship comes to page
Mm.
42, my lord,
Mm.
para 14,
Mm.
under the above mentioned facts and circumstances, and in view of the nature and gravity of the offense and
Mm.
punishment prescribed for the same, this
Mm.
court is of the opinion that it is not a fit case for grant of privilege of bail under 439.
Mm.
My lord, the Honorable Supreme Court says there should be a categorical finding of the High Court that the accused is prima facie, is guilty of the offense, prima
Mm.
facie, unless the trial, my lord, establishes the same.
Have
So
you gone through the
therefore,
other paragraphs of this order?
other paragraph, my lord, what I'm trying to say,
Uh,
my lord, today, I am not
And regarding this compliance of section 37?
Yes, well, today what I'm trying to say, Lordship will kindly give me 2 days time. Those two judgments of the Supreme Court, I'll try to differentiate. And
Mm.
I will also try to satisfy your
No,
Lordship.
no, we will not hear you on this point.
No, my lord, in fact, today in the morning, I have received, my lord, this particular bill application. My lord, it was with my lord junior who left, my lord, it was not in the present station, it
Mm.
was outside of the station. So what I'm trying to say, Lordship will kindly grant me 2 days time. On day after tomorrow, your Lordship will hear it. I will satisfy the maintainability.
No, we have to call for the record from the trial court.
Yes, then your Lordship, because what I'm trying to say, charge was framed in December.
Mm.
If by this time, my lord, my lord, witness have been examined, then that would be a change circumstances. If nothing has been stated against me, then your
Mm.
lordship can consider that aspect of the matter also.
Mm.
Up to the status report.
Now you tell me what is the change of circumstance?
My lord, change of circumstances would be if by this time, my lord, the witnesses have been examined because the charge was framed in, my lord, December 23.
No,
Fine.
might have been examined or had been examined. These are two different
My
circumstances.
lord, that instruction I don't have. My lord, what I'm trying to say, if your
Hmm.
lordship finds that 1 or 2 witnesses does not say anything against me, that can be a ground for consideration of the bail application, my lord. And
But
secondly,
before filing the application, you have to satisfy the court
in that
that
respect-
such and such
Correct, but
witnesses
in-
have been examined and they have not implicated you.
correct, my lord. In that respect, lordship will, my lord, allow me 2 days time for the purpose of maintainability, my lord.
Okay. As prayed for by Mr. Talukdar, learned counsel for the accused, recessal is the matter after 2 days,
On Wednesday. Lordship, on Wednesday,
Thursday.
Obliged.
on
Well,
item 3,
Lordship, the matter will be passed over for the time being, Your Lordship, after some time.
item 4,
Sir,
Item 3, Lord. I was on Lexington. May it please, Your Lord. This petition is directed against an order whereby the learned court below granted impeachment to the respondents who sought impeachment in a suit for specific performance. In fact, this petitioner, Your Lordship, and the proforma respondent number 15 to 25, there was an agreement to sale of land. Since the agreement was not acted upon, Your Lordship, the
No,
petitioner.
you tell me one thing, if the decree could not be executed in the event of passing by the learned trial court without implementing the respondents, can it be a decree?
So far, the
Hmm.
issue involved in the title suit is whether the contract is there is a specific purpose of contract is
Hmm.
to be granted or not.
No, that's all right.
Yes,
That aspect has been considered by the learned trial court. Trial court has held that without impleting the respondents, no decree can be passed.
Now, what they are saying is that, your lordship, that they are having title over the land.
Hmm.
Now, whether the issue of title can be decided in a suit for specific performance of contract, your lordship,
Hmm.
that issue cannot be gone into. At
No,
best-
the other question is, you answer me,
Yes,
whether the decree can be executed.
if they raise objection at that time, your lordship, the execution court will see
Hmm.
into it.
Hmm.
Or in the meantime, they may file also a title suit against those respondents and they may come.
Anyway, at this instance, let notice go.
Just I want to rely on a judgment of the Honorable Apex Court in this.
We have seen it, the trial court has also discussed the same.
Yes, discussed, but he has not followed, your lordship.
Hmm?
But not followed the
Hmm.
ratio of the case, your lordship.
Well, let the other side appear.
So they may appear, your lordship. In the meantime, your lordship, the impugned order may be stayed. What purpose will be served? Whether the trial court can decide, your lordship, that who is the owner of this of the property, your lordship, that
Hmm.
issue cannot be gone into in a suit for specific performance. And if there and even if a decree is passed, it will not bind them, your lordship. That is what the Supreme Court has said. And they have an option that they may file a separate title suit also, your lordship.
Heard Mr. M.S. Loskar, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner, read it section 151 CPC, the petitioner, Mohammad Afzal Hussain Loskar, has challenged the correctness or otherwise of the order dated 24/7/2024 passed by learned civil judge senior division number 1 Kasar Silsor in Mizje case number 250 of 2023, arising out of title suit number 93 of 2023. It is to be noted here that by impugned order dated so and so, the learned trial court has allowed a implement petition filed by the respondents. Peruse the petition and the documents placed on record, and also peruse the impugned order dated 24/7/2024. Let notice be issued to the respondents, returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today.
Pro forma respondents may not be required, your lordship. Whether steps is required to be taken on pro forma respondents, it may not be required. I have made them because
Find out who are required to be served.
1 to 15, your lordship. 1 to 14.
1 to
14.
1 to 14. Later on, Mr. Loskar, learned counsel for the petitioner, submits that notice is required to be served only up to respondent number 1 to 14, and no notice required to be served upon the performer respondent from 14 to 15 to 25. 25. And having considered the submission of Mr. Loskar, learned counsel for the petitioner, and also considering the facts and circumstances on the record, operation of the order, impugned order dated 24/7/2024 is state till returnable date. List after 4 weeks.
Oblige.
Party number 4,
Password for typing also.
item 5,
Please, your lordship. Lordship, I am the plaintiff lordship in this case, and I filed an application for adjournment to adducing a DW2 lordship. Page 60 and extra 5 lordship. In fact, there are 2 suits pending between both the parties. The respondent filed 1 suit and I have filed my counterclaim. So Basically, I am the plaintiff in this counterclaim, but as a defendant, I want to adduce DW's lordship. Annexure 5.
So
page
evidence
15.
has not been closed.
No, lordship. That was, adjournment was rejected and only my DW was accepted and I was not allowed to adduce any further evidence, lordship. So my humble prayer before your lordship, only one date may be given, I will appear and submit the DW.
Okay.
Lordship.
Heard Ms. R.S. Soduri, learned counsel for the petitioner. And also, no. This,
Lordship,
in this
I am
petition,
saying to dispose of this matter at motion stage, lordship, only one
under
date.
Article 227 of the Constitution of India, read with Section 151 CPC, the petitioner Robin Malo has challenged the correctness or otherwise of the order dated 14/5/2024 passed by the learned civil judge junior division North Salmara, Ovaipuri in case number 42 of 2021. Which will make it old TS number 7 of 2015. It is to be noted here that by the impugn order dated so and so, the learned trial court has allowed the petition, partly allowed the petition number 990 of 2024, by which adjournment was tried for. Adjournment was granted, but examination of DW2 is rejected
Yes, lordship.
and rejected the prayer
DW
for
was
allowing
accepted,
to
lordship.
adduce evidence of DW2 along with documents to be exhibited. Ms. Soduri, learned counsel for the petitioner, submits that only one date may be given to the petitioner to adduce evidence of DW1. Para, having heard the submission of Ms. Soduri, learned counsel for the petitioner, I have gone to the petition and the documents placed on record and also perused the order dated 10/5/2024. The petition is annexed here as annexure number.
Lordship, that is page 60, annexure 5, lordship. My engaged counsel filed the petition, lordship.
What is the number of the petition?
Lordship, that your lordship will find page 61. 990 of 2024.
It is to be noted here that petitioner is the defendant in title suit number 7 of 2015, which is renumbered as title suit number 42 of 2021, pending before the Court of Learned Civil Judge, Junior Division, North Salmara, Ovaipuri. The said suit is pending at the stage of DW. On 10/5/2024, the petitioner has filed a petition number 990 of 2024. Praying for another date for examination of the DWs. But the learned court, trial court, by its impugn order dated so and so, has allowed the pair of adjournment but rejected the pair for adducing the defendant's witnesses. Para. Next, that is fixed for what purpose?
Lordship, commissioner was appointed and for cross-examination of PW's, lordship. Last paragraph, your lordship, both sides are directed to appear for cross-examination of PWs before the learned commissioner on 2/7/2024 and 2/7 thereafter, Lordship, fixed 26/7/2024 for report from the Commissioner. On 2/7, we have already submitted that we are going to file a petition before the Honorable High Court, Lordship.
Last line to keep it. It appears from the impugned order dated 14/5/2024 that on that day, the petitioner could not produce the evidence of other DWs showing the cause of illness, but the learned trial court has dismissed rejected the said pair on the ground that no medical document have been annexed with the petition. So have you furnished the medical documents of the witnesses today in this petition?
No, Lordship, the petition was filed by my engaged counsel saying that the petitioner, defendant is, Lordship, facing illness, so he could not appear today, Lordship. So DW1 was submitted on that day and adjournment was sought for reducing DW2 along with all documents, Lordship. So
Sir,
only one date, Lordship, you will reduce all
having-
the DWs.
Heard the submission of Ms. Chaudhary, learned counsel for the petitioner, and also considering the facts and circumstances on the record. And further considering the fact that the cases, the evidence of the witnesses have not yet been closed by the learned trial court. This court is inclined to allow this petition. It is provided that the learned trial court shall afford another opportunity to produce the evidence of DW in the case in hand, and thereafter proceed with the trial in accordance with law. In terms of above, this CRP's dispose of at this motion is itself.
Deeply obliged, Lordship.
Item number 6.
I appeal to Lordship. Lordship, the petitioner is an advocate by profession. But kindly see page 11. That could of the affair.
Okay, at this instance, we'll call for the case ID.
Yes.
Investigation completed or
No, not completed. It's
going on?
Well.
Heard, Mister, your good name, please.
P.A. Ahmed.
P.
P.A. Ahmed.
E.A. Ahmed, learned counsel for the applicant, and Mr. Parasar, learned additional PP for the state respondent. Pending arrest in connection with dispute PS case number T84 of 2022 under section T41, T47, 427, 34 IPC, edit section 120B, 468, 423, 471, and section 409 IPC. This application under section 482 of the BNSS is preferred by applicant Moinul Haq for grant of PRS bail. Para. Having heard the submission of learned advocates of both the parties, it is provided that Mr. Parasar, learned additional PP, shall produce the case diary before this court on
18/9, my lord. 18/9.
No, this is a dispute, yes.
This one. My lord, on Friday, 13th.
And till them interim.
Sorry.
Earlier, Udon, my lord, 13, my lord. 13. Items for admission, item number 7.
Yes.
Yes, Your Lordship, in this matter, we are going to file our affidavit, Lordship.
Pardon?
Foreign on behalf of respondent number 1, we are going to file our affidavit, Lordship. Which time may be granted.
A date will be given, madam, after vacation, a fixed date will be given.
By respondent number 1.
Education Department, Lordship.
Secretary, madam.
Respondent number one is the state of Assam.
Yes, Lordship. Lordship, one, two, three, four, five.
Since when it is pending?
19 million.
Total of 19, Lordship.
Heard, Mr.
B Pulkar.
Learned counsel for the petitioner and Ms. Esmore, learned counsel for the respondent number
1 to 5, Lordship.
1 to 5. Office note dated 29/7/2024 indicates that no affidavit in opposition has been received from the respondent till date except respondent number 6, 7, and 8. Ms. Moore, learned counsel for the respondent number 1 to 5 submits that she may be granted 2 weeks time
Lordship.
to file affidavit in opposition. Pair is accordingly allowed. Pair is allowed for the last time.
A
No
date,
further opportunities will be given to you. Next,
may I pray for a date, my lord? A date may be fixed, date may be given, my lord.
date.
Then after vacation,
After 11th of November, my lord.
November 11.
Of like,
Item 8.
May please, your lordship. On the last two occasions, they
Lordship,
found time to
our-
file affidavit, lordship.
Instruction is awaited, Lordship. We have to receive our instruction.
Otherwise, it is a covert matter, lordship.
Covert matter by
They required a copy, lordship. Similar writ petitions have been disposed of by this honorable court. Similar set of writ petitions have been disposed of by this honorable court, lordship. It starts from page 40, lordship. I have annexed the order, lordship.
page number
40, lordship. We also fall in the category of 170 t-shirt, lordship. Page number 40, lordship.
Yes, madam.
Yes, after 2 weeks, Lordship. In the meantime, I will obtain instructions.
No, if it is covered case, what is the requirement for
But Lordship, we have to,
filing?
but Lordship, we have to go through the instruction, Lordship.
Last two occasions also they have short time, lordship. And one of the petitioner is going to retire this year, lordship.
2 weeks only.
No,
Then-
no, only we will grant you 1 week time. We will
Lordship.
direct to list this matter on Monday.
Lordship,
Heard Mr. Bordoloi, learned counsel for the petitioner, and Ms. Esmore, learned counsel for the learned government advocate for the state respondent. While Mr. Bordoloi, learned counsel for the petitioner, submits that this is a covert case in view of the order passed by this court in
WBC number
WPC number
8694/2018, lordship. Page number 33, your lordship.
8694 of 2016,
18, lordship.
2018. Order dated
Order dated 12/8/2021, lordship.
12/8/2021. 12/8/2021. And therefore, Mr. Bordoloi contented to pass similar order. Whereas Ms. Moore, learned government advocate, submits that she may be granted 2 weeks time to file counter affidavit. However, considering the facts and circumstances on the record, Ms. Moore is granted 1 week time.
Lordship.
Recess shall list the matter on next.
Lordship, can it be Wednesday, lordship? Next
Wednesday.
lordship.
Okay, well,
18/9. Item
Objection,
9.
lordship.
Lordship, this case was initially pending before the Honorable District Judge Kokrajhar.
Hmm.
Thereafter, due to the amendment in the Assam Agra Civil Courts Act,
Hmm.
it has been transferred to this court, Your Lordship. It was admitted and it was pending, Your Lordship. So under such circumstances, I have gone through the record. The office note says that it is listed after transfer, but the appeal memo is not in the format of the Honorable High Court, Your Lordship. So I may be permitted to file an appeal memo in the Honorable High Court's format before the registry, and it may be listed thereafter.
Heard Mr. Vijay Mukherjee, learned counsel for the petition, appellant. Mr. Mukherjee submits that this appeal was earlier preferred before the learned district judge Kokrajhar. And thereafter, which act was amended?
Assam, the Bengal Agra Assam Civil Courts Act.
Bengal Agra Assam Civil Court Act was amended, and the jurisdiction of district judge is fixed at rupees 20 lakhs.
20 lakhs.
Pecuniary jurisdiction of learned district judge is fixed at rupees 20 lakhs. And since the value of the present appeal is 35 lakhs,
23 lakhs.
23 lakhs, where it is mentioned?
In the site plain, Your Lordship. I think record is here, the plain, Your Lordship. It is 23
But in
lakhs.
the order, it is reflected as 32 lakhs.
Probably 32 lakhs.
You have not gone through the record. $32 lakhs. And as such, the learned district judge has no jurisdiction, no pecuniary jurisdiction to try to entertain the appeal. And this case has been received on transfer from the learned district judge in view of the order passed by this court in transfer petition number 88 of 2023. Mr. Mukherjee, learned counsel for the appellant, submits that this appeal is to be filed in the format prescribed for first regular first appeal, in the format of regular first appeal as prescribed in the rule. And therefore, he prays for granting him 1 week time to file amended. Amended cause title,
Memo of appeal, Your Lordship. The memo.
amended memo of appeal, where is accordingly allowed, registers shall raise the matter after 1 week.
Are number 10?
Lordship, the legal counsel is like in court number 1. So kindly pass on this matter for some time.
So it is listed for the first time today. After condonation of delay.
I apologize, Lordship, I was vexed now before. Lordship, this is an appeal against an ex parte order, Lordship. Delay was condoned by order dated, Lordship. And thereafter, this was 15/7/2024, Lordship. Notice was already issued and respondent once appeared. Thereafter, he did not. His counsel has withdrawn the wakalatnama, and thereafter also Honorable Registry had sent notice as per this Honorable Court's order, Lordship. But thereafter also he failed. In order dated 15/7, it's very clear, Lordship. So it's an ex parte order, Lordship. The appellant hearing was all along in the quarter of the
So in the interlocutory application for condonation of delay, the respondent appeared,
Yes, Lordship.
and thereafter here withdrawn the wakalatnama.
Wakalatnama. And thereafter, after this honorable court's order, since the lawyer has withdrawn the Wakalatnama, notice was issued. So which is very well reflected in the order of 15/7. Lordship.
This is a statutory appeal, Your Lordship. The appellant filed a suit and that suit was rejected, Lordship. Page 90, impugn order. And operative portion, Lordship, page 95. From the entire discussion made herein above, this court is of the opinion that plaintiff has put false averments with his knowledge of the real facts in his plaint, which are not supported by documents submitted by him, and he has also refrained from disclosing the essential facts which are material to his suit. Plaintiff suit also lacks a cause of action. The plaint of title suit number such and such therefore is rejected as per provision of Order 7 Rule 11A of CB. The plaintiff filed a suit, Lordship, for declaratory suit, and the defendant appeared, filed an application for rejection of plaints under Order 11 Rule, under Order 7 Rule 11, Lordship. That was allowed.
Heard Mr. Som, learned counsel for the appellant. This appeal under section 96 of the Code of Civil Procedure is directed against the order dated 29/7/2024, passed in Magic is number 65 of 2023, arising out of TS number 32 of 2023, passed by the learned civil judge. Senior Division Sibsagar. It is to be noted here that by impugn order dated so and so, the learned civil judge Senior Division has dismissed the plaint of the title suit number 32 of 2023 as per provision of section as per provision of order 7 Rule 11 within brackets small a of CPC. Peruse the memo of appeal and the grounds mentioned therein. And also peruse the impugn order dated so and so. Admit, let notice be issued to the respondent, returnable in 4 weeks, step be taken by registered post with AD and also by usual process within today. Registrar call for the record from the learned trial court. List the matter after 4 weeks.
Oblige, Your Lordship.
Item 13.
Right. For any of the parties concerned, it is a state.
May I please, Your Lordship? My lord, petitioner before Your Lordship were appointed as my lord, assistant teacher in their original venture school. Subsequently, my lord, their school were my lord provincialized, but due to my lord limited sanction of the post, they were not provincialized, my lord, and they are called my lord drop teachers. Subsequently, my lord, this honorable court passed one my lord general judgment. I have annexed this at page 15. To my lord regularize all those drop teachers, my lord, and thereafter, my lord, they were regularized. But as per this judgment, my lord, they were to give a, my lord, old pension policy, but they were brought wrongly under new pension policy, my lord, when they were provincialized. Then we approached this honorable court, and as per the order of this honorable court, my lord, they were brought under the old pension policy. But they were not given, my lord, the incremental benefit, my lord. This is their grievance, my lord. And last, my lord, order of their, my lord, taking into old pension policy is, my lord, page 42. By this, my lord, same order, this order passed by, my lord, Accountant General, giving their, my lord, GPF account, and now they are, my lord, under the old pension policy. Government side has not filed, my lord, affidavit yet, my lord. So, my lord, matter may be disposed of, directing the petitioner to submit, my lord, one representation to the.
Submit?
My lord, yes, my lord, they have, my lord, so long, my lord, have not filed affidavit, my lord. Petitioners may be allowed to file their representation before the director to consider their grievance.
Where is the representation?
Representation, my lord, they have not submitted, my lord, they will file.
No, you have not enclosed that representation with this petition.
No, my lord. Here, my lord, regularization order, my lord, page 34.
34.
34. Here, my lord, in this regularization, my lord, objectionable clause, they added, my lord, under the, my lord, the box, my lord, third paragraph, that they should give undertaking that they will get, my lord, new pension.
When the new pension rule came into force?
My lord, 2005, my lord. With
Five.
effect from, my lord, 1 to 2005, my lord.
And their service has been regularized with effect from?
It is regularized, my lord, in the year 2013, my lord.
13.
Yes, my lord. Then, my lord, they filed writ petition before this honorable court. Second writ petition, my lord, page 36. Here, my lord, this honorable court disposing of the writ petition, my lord, operative part, page 40. Here, page 40, my lord, the paragraph, my lord, from the bottom, my lord, it is third paragraph. For the aforesaid reason and considering the entire aspect of the matter, the state respondent are directed not to insist upon the undertaking from the petitioners as contained in their respective impugned appointment and regularization order dated so and so issued by the Director, Implemented Education Assam pursuant to the order of the state government concurred by the Finance Department of the state with regard to the acceptance of new pension rule that came into effect in the state from 1 to 2005 and to give them the petitioner the benefit of past service for the purpose of pensionary benefit as per Assam Service Pension Rule 1969 in terms of the direction contained in the said Jivan Chandra Dekka's case supramacy. Then, my lord, pass the final order, page 42. Lordship, kindly have a look. Here, name, my lord, and right hand side, my lord, date of joining, 1995, my lord. Now, my lord, humble petitioners are, my lord, entitled to incremental benefit from 18/1/1995, but they are not given by.
Yes, madam.
Yes, Lordship, I need to obtain instruction, Lordship.
Pardon?
Instruction is awaited, Lordship. Need to obtain it. It's a matter of 24 only, Lordship.
Maybe.
If my lord, kindly, my lord, we are allowed to submit representation, my lord. Then, my lord, their stand will be clear out, my lord, by speaking order. My lord. Nobody will be, my lord, prejudiced, my lord. Kindly, my lord,
So when it is expected to receive the instruction?
2 weeks, Lordship.
2
2
weeks?
weeks, Lordship.
We will grant you only 1 week time. You will file the affidavit in objection, affidavit in opposition. When their school was provincialized?
my lord, it is provincial, my lord, long back, my lord, 19. Is my lord stated, my lord, paragraph, my lord, 2. Provincialized on, my lord, 18/1/1995.
Heard Mr. A.M. Barguya, learned counsel for the petitioner, and Ms. S. Moore, learned government advocate for the state respondents. Ms. Moore submits that instruction from the respondents is still awaited and price for granting her 2 weeks time. However, considering the facts and circumstances on the record, Ms. Moore is granted 1 week time. Places and leaves the matter on COVID. Sorted. 25th. 25th of September.
Fine. Deep look.
Item 14.
May pleases you, Lordship. Pertaining to that, your Lordship, we have received instruction which we like to file our affidavit. Already affidavit has been sent for vetting.
When you are going to file the affidavit?
After 1 week, your Lordship, already sent it for vetting.
Heard Mr.
M. Sharma.
Learned counsel for the petitioner. And also heard Ms. Das, learned counsel for the
Secondary education.
respondent number.
Respondent number 1, 2, and 3.
1, 2, and 3. Who is for respondent number 4?
It's finance. Finance. H. Aliha name may be recorded, your Lordship. He is the standing counsel of finance.
Yes, Solia.
H. Aliha.
But he is not before the court. Why should we record his name? None appears for the respondent number 4. Miss Das, learned counsel for the respondent number, learned standing counsel for the respondent number 1, 2, and 3 submits that she has received instruction and prepared affidavit and sent the same for vetting. And press for granting her 1 week time. Here is accordingly allowed. Presses unless the matter.
Deeply obliged.
20 September.
20.
Item 15.
This is regarding computation of past service benefits for payment of pension matter. After notice was issued, the respondents have not yet referred back to the affidavit. They are ready with the instruction.
Yes, Lordship.
Or Mr. P. Bhardas. Yes,
Yes, Lordship, one instruction I have received, and that their past services are already allowed, Lordship,
allowed.
allowed, Lordship.
Okay.
Already allowed to receive past services.
So it appears that benefits have already been granted to you.
My lord, I have not seen it. If my lord fixes on very short date, perhaps the day before, the day after tomorrow also, I'll have a look from madam.
You furnish a copy to me. Heard Mr. P. Bhardas, learned counsel for the petitioner, and also heard Mr. S. Kumar, learned government advocate for the successor. Ms. Ford producing an order of the Director of Director of Elementary Education, Assam, Kailupara, dated 26 June 2023, memo number EE within bracket plan Ace stroke 2019 stroke 295 submits that the relief being sought for in this writ petition have already been granted to the petitioners. At this instance, Mr. Bhardas, learned counsel for the petitioner, submits that he may be granted 2 days time to obtain necessary instruction in this regard. Here is accordingly allowed. Recessal is the matter on Thursday. Thursday? Friday.
Friday on 13th.
Friday. Friday. Huh? A copy of this order. No, it was recorded. Have you?
Take a picture.
Okay. A copy of this order. No, a copy of the order produced by Ms. Kumar before this court be furnished to Mr. Bhardas during the course of the day.
16.
Please, Your Lordship. My lord, the petitioner hearings are all grade 3 stenographers, my lord, working in SCRT, State Council for Education and Research and Training. My lord, the petitioners herein are aggrieved by the reduction of their grade pay from the existing 8,700 to 7,400. My lord, if your lordship will kindly peruse the last order. My lord, on the last location, notice was issued, and this is the second time the matter has come up. So I think my learned.
Lordship, I want 3 weeks time, Lordship. I'll file affidavit, my lord.
The impugn order is at page 122. Yes.
You want 2 weeks time,
Lordship.
okay, heard Mr.
K. Mohammed.
Learned counsel for the petitioner and Mr.
R.K. Talukdar, my lord.
R.K. Talukdar, learned
Standing counsel.
standing counsel for respondent
Accountant
number,
general, my lord.
respondent number,
4, my lord.
respondent number 4. And any other respondent?
Lord, I am appearing for 2, 3, and 5.
2, 3, and 5.
P. Nayak.
B. Nayok. And for rest of the respondents?
One.
1. And Miss Esquire, learned government advocate for the respondent number 1.
Yes.
You are for respondent number?
4, my lord.
4. Accountant general.
Yes, my lord.
The learned
fact,
standing
the
counsel for the
SCRT sorry, my lord. Lord, in fact, the stand of the SCRT is also required in this matter.
SCRTO.
Because this impugn order was issued by
Lordship,
the
they kindly
director
go through the
SCRT.
impugn order, Lordship.
Yes.
Lordship will say it is a decision taken on the advice given by the accountant general. That is why I am saying let the affidavit of advocate, accountant general come, Lordship. If
Okay.
any clarification is required, definitely we will try.
Okay. The learned standing counsel for the respondent number 4 submits that he may be granted 2 weeks time to file counter affidavit in this petition. There is accordingly allowed recessal is the matter after 2 weeks. So do we fix a date?
Yes, ma'am.
27 September. For bail hearing, item 17.
May I please, my lord, my information is that because of financial crisis, he could not get the operation of his mother till today. So I pray the little accommodation, but 7 days time will be given. Otherwise, your lordship will pass an appropriate order.
Yes.
My lord, earlier rejected case, otherwise, my lord, on merit, my lord.
Have you received the case diary?
Yes, it's my lord, yes. Yes, very soon.
Mr.
That
S.A.
why,
Vishnu, the learned counsel for the
police has not
applicant
recorded
submits
our
that
statement also.
No. Statement recorded.
Recorded.
Yes. 9/8/24 interim order granted and 15/8/24 statement recorded, my lord.
Oh, recorded.
Statement is there.
So Mr. Visas, you do not know the latest question.
No, actually, my junior is his case, man. He has not informed me all these things. That's why I am waiting for it. If possible, will kindly extend me for 7 days time. Thereafter, your lordship will pass an approval, if not.
Mr. Visas, learned counsel for the applicant submits that due to poor financial condition, the applicant could not get the operation performed. Operation of his mother performed and praised for granting him 1 more week time. Here is accordingly allowed. Recessal is the matter on COVID. 18.
Yes, ma'am.
On 18. Till then, case ID shall be retained.
My lord, completely proceed.
Items for hearing under order 41 rule 2 CPC. Item number 19.
The parties here are brothers, your lordship. The suit was filed by the respondent for declaration of right title interest of an entire plot of land of the ancestral land, your lordship. And both the trial court and the first appellate court went on to declare the right title interest on the basis of the mutation entries in the name of the defendant, in the name of the plaintiff, respondent here, your lordship. By overlooking that, mutation does not confer title, your lordship. It was overlooked by both the courts. And it was held that since we did not challenge the mutation entries, so it was presumed that they have right title and interest over the entire case of them. So basically the suit was decreed on the strength, not on the strength of the plaintiff's case, but due to the weakness, since the defendant did not challenge the mutation entries, title was declared in favor of the plaintiff. So the substantial questions of law that I am proposing, your lordship, is at page 3. 1, 2, and 4 will be relevant, your lordship. 3 and 2 are same, probably. That whether mutation entry confers title, that is, and there are judgments, your lordship.
Heard Mr. B.J. Mukherjee, learned counsel for the appellant. This appeal under section 100 of the Code of Civil Procedure is directed against the judgment and decree dated 16/5/2024 in title appeal number 5 of 2023, passed by the learned civil judge, senior division, Lakhimpur. In dismissing the appeal on contest and thereby upholding the judgment and decree dated 31/5/2023, passed by the learned Munship number 1, North Lakhimpur, entitled suit number 17 of 2017 is 2017. Peruse the memo of appeal and the grounds mentioned therein. And also peruse the judgment and decree dated 16/5/2024, passed in title appeal number 5 of 2023, passed by the learned civil judge, senior division, Lakhimpur, and also the judgment and decree dated 31/5/2023, passed in title suit number 17 of 2017, passed by the learned Munship number 1, North Lakhimpur. This second appeal is admitted on the following substantial question of law. Number 1, whether the learned Munship can grant decree on the basis of weakness of the defendant's case rather than on proof of the element of cause of action by the plaintiff. Number 2, whether the learned courts below were justified. No, learned Munship as well as the first appellate court are justified to presume flow of title of the suitland in favor of the plaintiff alone on the basis of entry made in the Jamabandi, even when the names of both the plaintiff and the defendants appeared in the Jamabandi. Number 4, whether the learned trial court is justified in declaring the title of the plaintiff over the suitland when the claim is when the claim was made on the basis of unregistered actions and unproven family settlement. The court may also consider framing of any other substantial question of law at the time of hearing after due notice to the parties. Issue notice returnable in 4 weeks is to be taken by registered post with AD and also by usual process within a week from today. Rest shall call for the record from the learned court's filing. Please the matter of purpose. IA stand statement. This one.
Item 20.
Make things up. Well, not the background of the case is like this. Here was the first round of litigation between other party, my lord. But
Mr. Said,
my lord,
where is the substantial question of law in this appeal?
my lord, my lord, page 4. Three may be looked into, my lord. 3. My lord, 1, 2, that is 2 is not so important, my lord. 3. Substantial question of law, page 5. Arises as to whether the lower appellate court committed illegality by holding that the claim of the appellant was hit by explanation 4 and 6 of section 11 of the CPC. Because, my lord, my humble submission before your lordship, I was not party in the earlier suit. I was not a defendant there. Section 11. Explanation of this.
And any other?
Any other, my lord, sir? Then 4, my lord. A substantial question of law arises as to whether the lower appellate court committed illegality by holding that as the ownership of the respondent plaintiffs were decided in RSA. That is earlier suit, my lord. I was not on part and I was not party there. So the appellants were not entitled to raise any defense
So,
against the ownership.
this 4 is covered by 3.
4, 3, almost same, my lord. Now, my lord, substantial question arises as to what lower appellate court illegality by holding that non-implement of appellant is not sustainable because their mother and siblings were contested this section. So, my lord, mother and siblings may be there, but we the appellants were not party in the earlier.
So this is also covered by 3.
Well, 3 will do, my lord. 3 will do.
Heard Mr. MSek, a learned counsel for the appellant. This appeal under section 100.
My lord, I may be sorry, my lord, that Page 6, my lord, ground number 7, whether it can be taken into consideration. Almost this 3, my lord, 3 covers this to some extent.
So at the time of hearing, if necessary, we'll
Any other substance?
any other substantial question.
Oblige.
Read with order 42 of the CPC. Is directed against the judgment dated 25/7/2024 passed in Miss Appeal number 16 of 2019 by the learned civil judge senior division Dhuri. But in the cost title, we have not mentioned about the title execution case number 3 of 11 in the court of Munsif.
My lord.
Is it necessary to amend the cost title?
Not, it is not necessary, my lord, that execution case I am to mention. My lord, in the IA, I have mentioned, my lord, that execution is started.
But substantial question of law. Okay, we'll see.
My lord, it's a second appeal, my lord, direct, we used to go that substantial question of law. It's not a first appeal, my lord. In first appeal, something is ready.
What is the judgment?
Impugned judgment.
Yes.
It starts from 68, my lord. Not para 4 may be seen. Look into my lord. The case of the plaintiff is being briefed at. Last about 4-5 lines. Thereafter, Sumira died living behind him the following legal year. Now, my lord, from 6, 7, 8, they are the 8 and 9. They are the present plans.
You follow? Dhubri. In Miss Appeal number 16 of 2019. It is to be noted here that by impugned judgment dated 25/7/2024, the learned civil judge senior division Dhubri has affirmed the order passed by the learned Munsif Vilasipara in Meije case number 65 of 2012. peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugned judgment and order dated 25th July 2024, passed by the learned civil judge, senior division Dhuri, and also the judgment and order dated 17/9/2019, passed in Miss J case number 65 of 2012 by the learned Monsif Bilasipara. This second appeal is admitted on the following substantial question of law. Whether the learned first appellate court committed an illegality by holding that the claim of the appellants was hit by explanation 4 and 6 of section 11 of the CPC. The court may also frame any substantial question of law if deemed necessary at the time of hearing after due notice to the parties. Let notice be issued to the respondents returnable in 4 weeks. Step be taken by the expert post with AT and also by Excel process within a working or not within a week from today. Rest shall also call for the record from the learned trial court and also from the first appellate court. List the matter after 4 weeks.
My lord, this miss case may be taken. Stay, my lord. Stay petition.
Okay.
Order 41 rule 5.
Till returnable then.
My lord, till returnable.
Notice.
Lord, in the prayer, my lord, I have two prayer. Title execution case number 3/2011. That proceeding may be stated as well as this.
But you have not mentioned about that proceeding in the cause title of the second appeal.
And in the second appeal, I have not, my lord, but in the IA, my lord, I have detailed mention. Detail mention.
IA is the offshoot of the main appeal.
My lord, if your lordship please to stay the impugned order, that will do. Yes.
Okay, we stayed it. Okay. We'll come back after 5 minutes.
Over a my lord plot of land measuring my lord 4 kataga. This is the pending my lord, but ultimately the suit has been dismissed, my lord. Your lordship will find, and your lordship will find, my lord, that defendants also did not file their written statements in this case. Your substantial question of law we have formulated, your lordship will find at page 6A. No written statement has been filed, your lordship, and the procedures, my lord, under order 8, rule 10 was not followed. Then in the appellate court, my lord, will file an application for adducing of additional evidence, your lordship, under the my lord, provisions of order 51, rule 27. That application was neither accepted nor rejected by the court below. Judgment was pronounced. And third, my lord, C, so far as C is concerned, my lord, this is concerning perversity, your lordship, because some evidence, some exhibits, even the pleadings, my lords, were not taken, or these are already ignored by the my lord court below, resulting into perversity, your lord. Now, my lord, I take your lordship to page 48, your lordship, so far as the case of the plaintiff is concerned.
But where is your substantial question of law?
My lord, page 6A, your lord.
6A.
6A, your lord. First substantial.
But it is not part of the memorandum of appeal.
It is a part of the my lord.
This is separately. This is enclosed separately.
My lord, substantial question of law we have formulated, my lord.
It should be part of the memo of appeal in view of the subsection 3 to section 100.
No, it is a part, your lord. It is a part of memo of appeal, or otherwise, my lord, your lordship may see the grounds, your lord. Grounds, my lord, your lordship, these are almost the same thing, my lord, page 4, your lord.
Firstly, my lord, although my lord, no written statement was filed by the defendants, my lord, I find, my lord, that the procedures under order 8, rule 10 was not followed here. My lord, it has been stated that if no written statement is filed, then judgment is to be pronounced against the defendants. That procedure was not followed, then my lord, grounds B, my lord, we filed an application in your lordship under order 41, rule 27. And my lord, this is an application for reducing additional evidence. Application for reducing additional evidence cannot be rejected, your lordship. It is to be taken into consideration, my lord. During the hearing, my lord, judgment is silent, your lordship. And your lordship will find, my lord, here in this case, the plaintiff filed the suit, my lord. For declaration of his title, my lord, I am taking your lordship to page 48. For declaration of his title over Schedule 3 land, dear lord. And his case is that, my lord, that he purchased, my lord, the suit land, my lord, by Exhibit 4, and that suit land has been mentioned, my lord, in Schedule 1, page 50, my lord. There are two darks number, my lord, 442 and 441.
That's all right, but this substantial question of law are not part of your memo of appeal. It is a loose sheet enclosed with the memo of appeal.
My lord,
You see subsection 3 to section 100. You see.
My lord, in this, my lord, I am filing, my lord, this second appeal, my lord, for the
Maybe, but we are not accepting it.
For the 40 years, I have filed your lordship.
40 years.
Yes. 40 years, my lord, I am practicing with more than 40 years, your lord. And this is the forms, my lord, I am, my lord, adhered on this is your lord.
Maybe you are following, that is a different aspect. But can it be said that you have complied with the provision of subsection 3?
Pardon to formulate that substantial question of law.
It is upon the court.
Is upon the court, your lord.
But you see the section.
That pardon, my lord, we, my lord, frame the ground. Pardon, my lord, to formulate, my lord.
No, you go through the subsection 3 of section 100.
It is upon the court, your lord. My substantial question, your lordship, may not be pleased with that. So, generally, it is the, my lord, court which formulates the substantial question of law.
Definitely, court will frame the substantial question of law, but what section states?
For the sake of convenience, your lord. For the sake of convenience of the court, we generally, my lord, we assist the court by filing a slip, your lordship. That is the
No,
summary.
are you complying with that provision?
3, my lord. See, in an appeal under this section, the memorandum of appeal shall precisely state the substantial question of law involved in the appeal. So, in the ground, we have stated, my lord, what is the substantial question of law. And then, my lord, in order to be precise, my lord, and in order to achieve.
No, whether there's a grounds can form the substantial question of law.
Substantial question of law is that, my lord, that the learned court below, firstly, did not adhere to the procedures under Order 8, Rule 10, then procedures under Order 41, Rule 27, and, my lord, Ishardas case, my lord, 2001 SCC 434, it ignored the evidence of PW1, PW4, and, my lord, the sale deed Exhibit 4, and came to a finding, my lord, that plaintiff is having, my lord, instead of 5 kathas.
No, that's all right. My question is, are you complying with the provision of subsection 3 to section 100? Because
subsection 3 of 100, my lord.
Yes.
In an appeal under this section, memorandum of appeal shall precisely state the substantial question of law involved in the appeal. Now, my lord, second court.
You have not mentioned the substantial question of law in the memo of appeal. You have enclosed with the memo of appeal as page number 6A.
This is the substantial question of law. We have annexed to the memo of appeal, your lord.
No, can it be said that you have complied with that provision?
My lord, my submission will be the same, your lordship. That we have, my lord, stated grounds of appeal in, my lord, this, my lord, precisely states the substantial question of law in the grounds we have stated, your lordship. And 6A, my lord, your lordship may ignore that, your lordship. Your lordship may go through the grounds and formulate the substantial question of law, your lordship. My lord, where the court is satisfied that a substantial question of law is involved in any case, it shall formulate the question. Who is to formulate the question? Court is to formulate the question. It is our, my lord,
No,
assistance to the
there
court.
is no doubt about it. The court will definitely frame the substantial question of law.
No, grounds, my lord, grounds, your lordship is to see, grounds is a part of the memo of appeal, and your lordship is to see what are the grounds. And if your lordship is satisfied after going through the grounds that there is a substantial question of law, then your lordship is to formulate this, your lord. Our page 6 is nothing, your lordship.
So then you make necessary correction in the memo of appeal that these grounds are the substantial question of law.
As your lordship pleases. But I do not know, my lord, what is the other form after 40 years or 42 years, my lord. I do not know.
No, that is different aspect, but you have to comply with the section. You have read the section on several times or several times.
I do not know, my lord. With all respect, your lord.
List the matter after 1 week so as to enable the learned counsel for the appellate to file amended memo of appeal incorporating the substantial question of law in view of subsection 3 to section 100 CPC.
22.
Apply. Apply.
May I please, your lordship? This, my lord, the appeal is, my lord. Again, the judgment are ordered, my lord, on 27/5/24 passed by the, my lord, Civil Judge Lakhimpur. This case suit is, my lord, specific performance of contract, my lord, and this suit is decreed, and the appeal preferred by the defendant, that is decreed, and now defendant before this court for second appeal, my lord. That, my lord, that the main cases are there is an agreement for sale, my lord. That is a part of, my lord, claim that is denied by the defendant in their WS. So they are required to be proved. But how they prove, my lord, that the saying that the PW2 proof, but the PW2 evidence is already expunged, but that has not recorded. He is supporting, and my lord, PW4 also, my lord, he said that he do know nothing about the execution. And, my lord, that the defendant are also co-partner, my lord. But, my lord, they are not bound by the, my lord, that agreement filed by the plaintiff. My lord, that substantial question of law here, my lord, that page 5, my lord. 1 and 3 is the same, my lord, that 3 is more elaborate. One is, my lord, whether the unregistered agreement of sale, mati, dokhol, hostantor, photopatra, that is exhibit 5, which is root of the suit, is duly proved by the plaintiff under section 67 of the Evidence Act, as required by law, which is specifically denied by the defendant, their written statement. That 2 is, my lord, whether the court below is justified to hold that the co-partner are bound by the agreement for sale executed by the another co-partner, those who are not parties to the said agreement for sale, my lord. For a time being, my lord, I am giving, my lord, how this is a perverse, my lord. That the PW2 which is scribed, my lord, and what regarding him, the part on 6/7/19. Order is at 6/7/19 says, my lord,
the parties are represented by their learned counsel. Summon issued to PW3 Sri Komal Bora, written without being served with report that witness is suffering unsoundness of mind. In view of that, additional as well as main examination sheet filed on affidavit of PW3 Sri Komal Bora be taken off the record. So, my lord, in my lord, findings of the court, my lord, that his evidence is relied, my lord. Your lordship may kindly, for a moment, my lord, in trial court judgment, my lord, in trial court judgment, my lord, page 57. Page 57. Page 57, my lord. Second para, my lord, in order to, page 57. In order to decide the issue of plaintiff side, examine 4 witnesses and prove the 20 number of exhibit. On the other hand, defendant examine 7 witnesses and prove the 16 number of the plaintiff 1. Plaintiff number 1 corroborated her claim regarding the money of this money by the late Sondeshwar Das proved by money received, exhibit so and so. Prove the money received executed by the imam. The main thing is, my lord, the plaintiff also proved the unregistered sale deed. The plaintiff cannot prove, my lord, the plaintiff, it has to be proved by the scribe or the witness. And, my lord, the exhibit 5, plaintiff, other witness PW2, 3, and 4 also support. How, my lord, he wants to expand his, how can he support? The PW3, PW4 also prove the signature. No, my lord, that is, and the same thing is, my lord, that in page 31, my lord, the appellate court, without going to the record of the evidence, my lord, page 34, my lord, the same reiterate. Page
So
30.
according to you,
Is
which
a
are
purpose, my
the
lord, and not that my lord, that the for a moment, my lord, agreement is, my lord, annexed in the plain, my lord, 82. How? 82, page 82, my lord. It is an unregistered agreement, my lord. Page 82, for a moment, my lord. That page 82, my lord, the Assamese version. That is, my lord, the Komal Bora, left hand side, my lord. In Assamese 25/6/13, it is overwritten, my lord. And in Topsil, my lord, that Dag number is overwritten. And, my lord, interestingly, in the overleaf, my lord, overleaf, witnesses are signed in the overleaf, where no signature of executed. So, my lord, it is required to be proved under the law, under section 67 of the Evidence Act, that has not done properly. Once the, my lord, witnesses expand, how can his witness can be relied? So, my lord, the substantial question of law would be, my lord, that one, my lord.
Komal Bora was the scribe.
Yes, my lord.
But other witnesses are there.
Other witnesses are, my lord, that
They have been
regarding
examined.
witness number 5. What witness number 5 says, my lord, it's very interesting. He says, my lord, witness number 4. Here, my lord, in page 2, there is 3 witnesses, my lord. Witness number 4, he says, my lord, witness number 4, Prodorshok 5 খনত মই সহি কৰা নাই প্ৰদৰ্শক 5খন কোনে কত লিখিলে মই ক'ব নোৱাৰিম গোচৰ লগা মাটিৰ বিষয়ে মই একো নাজানো. This was the cross examination.
No, maybe, but in page number 63, Komal Bora has been shown as PW2.
PW2.
He was examined.
His additional evidence expands because he was not come to the court for cross examining. That is the
No, earlier he was examined.
Not examined, not at all examined. He's taken off the record, my lord. Is a certified copy I have produced before this. Taken off the record.
And this Divya Deuri.
Acha, Deuri, my lord. Deuri, what he says, my lord? Deuri is saying, my lord.
Jitu Mohanto.
Acha, Deuri is saying, my lord. প্ৰদৰ্শক 5খন লিখাৰ সময়ত জয়শ্ৰী ঘোষ মানে প্লেইণ্টিভ চন্দ্ৰেশ্বৰ দাস মই আৰু কমল বৰা লিখক জিতু মহন্ত আছিল. He is saying that matlab means he also do not know who is. He is a likhok Jitu Mohanto. Jitu Mohanto is here, my lord. one of the witness of the agreement, my lord, Jitu Mohanto says in his cross-examination, my lord, Jitu Mohanto, what he said, he do not know about the performance of the execution of the agreement, my lord. He is the witness. Your lordship may kindly page 82. Page 82. Page 82, my lord. Jitu Mohanto is there. Page 82. Page 82, my lord. The next page, my lord, page 83. Dibbo Deuri on Raju Subba is not examined. Jitu Mohanto. Interestingly, here not there is in this left page, my lord, the above the treasury officer, that is the stamp, my lord. That means overlift of the page, and here no sign of executed. Then Jitu Mohanto what say he? Jitu Mohanto say, my lord, Prodorhok 5 মই সহি কৰা নাই Prodorhok 5 কোনে কত লিখিলে মই ক'ব নোৱাৰো for the time being your lordship may go through. So and then that
And what about this Dibya Deuri?
my lord,
What is the deposition of Dibya Deuri?
Kamal Bora is not written this, that Jitu Mohanto is written the, but that is right. But so they have not gone through the evidence on record by the trial court, my lord, that to that extent it is perverse, and lordship may that the substantial question law I've made, my lord. The three is, my lord, more specific. At page 6. That whether the
So
court below
1 and 2 are not relevant according to you.
oh, no, 1 and 3 is the same, my lord, and 2 is relevant because they co-partner, they have, my lord, that co-partner Govinda Paging, my lord, is page 109. They have, my lord, separate patta, my lord. 1 and 2 may your lordship him and any other substantial lordship have at the time of hearing.
So 2 and 3 or 1 and 2?
2 and 3, my lord. 2 and 3 is sufficient.
2 and 3. Heard, Mr.
C. Goswami.
Learned counsel for the appellate. This appeal under this second appeal under section 100 of the CPC is directed against the judgment and decree dated 17/5/2024 and 22/5/2024 passed by the learned civil judge, Senior Division Lakhimpur, in title appeal number 03/2022. By which the learned civil judge, Senior Division, has dismissed the title appeal referred against the judgment and decree dated 5/3/2022 and 17/3/2022 passed by the learned Munsif number 1 Lakhimpur at North Lakhimpur. In title suit number 31 of 2020, original case number 33 of original case number
24.
TS 24 of 2016. Where is the memo of appeal and the grounds mentioned therein, and also where is the impugned judgment and order, judgment and decree dated 17/5/2024 and 22/5/2024 passed by the learned civil judge, Senior Division Lakhimpur, in title appeal number 03 of 2022, and also the judgment and decree dated 5/3/2022 and 17/3/2022 passed by the learned Munsif number 1 North Lakhimpur, in title sub number 31 of 2020, between bracket original case number TS 24 of 2016. This second appeal is admitted on the following substantial position of law. But this 2 and 3,
2 and 3, my lord.
2 and 3. Number 1. Whether the courts below know whether the learned trial court and also the first appellate court are justified in holding that co-partner are bound by the agreement for sale. Within bracket, মাটি দখল হস্তান্তর খাতপত্র executed by another co-partner who were not parties to the said unregistered sale agreement and decreed the suit for specific performance of contract. Number 2, whether the learned trial court and also the first appellate court are justified in holding that the execution of deed of agreement of sale, within bracket মাটি দখল হস্তান্তর খাতপত্র, is proved in accordance with law, while the evidence of PW2 was expunged. PW2, the scribe of the deed was expunged, and PW3 who was one of the witness of the deed admitted that the deed was written by PW4 and PW4 also admitted that he do not know about the execution of the deed. And on such count, the finding of the learned first appellate on a trial court as well as the first appellate court holding that the deed of agreement of sale is proved is perverse. Let notice be issued to the respondents returnable in 4 weeks. Step be taken by registered post and also by usual process within a week from today. Registration call for the records from the learned trial court as well as from the first appellate court. List the matter after 4 weeks.
I for execution of stay, my lord, under order 41 rule 5.
Other order is any? Stay there.
I am a state, my lord. Obliged.
23.
You can take this
State I will
evidence
take
statement.
23.
Please, Sir Lordship. Lord, the proposed questions, Your Lordship finds at page 7. Lord, except for 4, my lord, I'd like to press for all 1, 2, 3, all 3.
Pardon? Except for
4, my lord, I'd like to press all 3, my lord.
What is this constructive notice?
My lord, in fact, my lord, if I just place the background, my lord, there was this plaintiff admittedly was the original owner, my lord. Now, there is a sale deed of 2008 by which he had sold his land to defendant number 1, my lord. Thereafter, defendant number 1, my lord, sold the land again to defendant number 2. And defendant number 2 eventually sold it to us 3 and 4 in the year 2012. Now, during this entire period, these are registered instruments of sale, my lord. And entire period, the names of the intermediary purchasers were recorded in the revenue records, my lord. And we were only paying the land revenue. So, in 2013, my lord, the plaintiff files a suit saying that the initial deed of 2008 is a forged deed. Now, since from 2008 till 2013, the revenue records have been corrected. We've been paying land revenue. There are evidence to that effect. And we have also been possessing the suit land. And suddenly in 2014, he files the suit. my lord. Therefore, we said that as per Section 3 of the Transfer of Property Act, if he had made the necessary inquiry as to who is paying the land revenue, then he would have had notice. So even if he did not have actual notice, had he checked the revenue records, he would have had a constructive notice, which is why he should have filed it within 3 years from 2008. And more importantly, my lord, the third question, I'm sorry, there's a typographical error. It should have been committed rather than come, my lord. What had happened, my lord? Both the trial court and the first appellate court said the burden of proof is upon me to show that the deed is genuine, rather than the plaintiff has to show that the deed is forged. In fact, a judgment was also relied on that the initial burden will always remain on the plaintiff. He has to make out a case, only then he'll shift to me. Now, but the trial in the first appellate court held that no, you are asserting the positive, so therefore you have to prove it. Now, otherwise, my lord, there are two judgments which I can place, my lord. This is wrong on two counts, my lord. Firstly, it is the plaintiff, so initial owners will always be on him. And secondly, my lord, these are, since the documents are registered, they have a presumption attached to it, and therefore the burden would always be on them to rebut the presumption.
But Mr. Data, learned counsel for the appellant. This second appeal under section 100 of the Code of Civil Procedure is directed against the judgment and decree dated 05/2024 passed by the learned additional district judge Borpeta in title appeal number 03/2020. Is to be noted here that by impugned judgment and decree dated so. The learned additional district judge Borpeta has affirmed the judgment and decree dated 23/12/2019 passed by the learned civil judge Borpeta in title suit number 18 of 2013. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugned judgment and decree dated so and so passed by the learned additional district judge, and also the judgment and decree dated 23/12/2019 passed by the learned civil judge Borpeta in title suit number 18 of 2013. The second appeal is admitted on the following substantial question of law. Number one, whether the finding of the courts below in the issue regarding limitation are erroneous for not having taken note of the various circumstances indicating constructive notice of the respondents struck plaintiffs. Number two, whether the learned courts below committed illegality by cancelling the registered instrument of sale, that is Exhibit B, without a rebuttal of presumption under Section 60 of the Registration Act 1908. Number three, whether the whether the learned courts below committed error of law by casting the burden of proof upon the defendants rather than upon the plaintiff who had alleged forgery of registered instrument of sale. Let notice be issued to the respondents returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. Restriction call for the record from the learned trial court as well as first court. This is the matter after 4 weeks. I
I sustain. Obliged.
Items for orders, item number 24 to 31 by VC note. No, wait, number. My lord, all these appeals, my lord, are pending since on 2019, my lord.
Yes.
Up to now, my lord, in my other appeals, my lord, they are already the railway has already withdrawn the appeals, my lord. Mostly these also, my lord, they withdraw, but now nobody is appearing to them, most probably, my lord.
You are for the respondents.
Respondent in two cases, my lord. LA case number 11 and LA case number 17, my lord.
Item 26 and 30, your lordship.
You know, earlier also nobody appeared on behalf of the railway, my lord.
Is there any standing counsel for railway?
There is, their names are also shown in deposits, your lordship.
Who is?
In most of the days, Mrs. Uma Chakraborty
S.
appeared.
Mohanto.
Uma Chakraborty appeared, your lordship. Early days. U Chakraborty.
It's item number 20. 24. 24.
26 or 20.
No, the answer is 26. 26. Itu naman. Tapi kung may. You go for 26 and
30.
26 and
30. 30.
What's that? So, Mr. Das, what to do?
My lord, I leave it to Lordship, my lord, because of the cases are pending because of this pendency of this appeal, my lord. We are not getting the compensation, my lord. The negotiation compensation.
So, let us fix a very short date. On that day, if the counsel for the appellant remain absent, we will dismiss it.
That man, my lord.
None appears for the appellant on call. However, Mr. N.C. Das, learned senior counsel, assisted by Mr.
A Das, your lordship.
A. Das, learned counsel for the respondent number. For the respondent.
Respondents in item 26 and 30.
Respondent?
One, your lordship.
Respondent 1.
1 in 26.
Respondent number 1. Present. It appears that this appeal was preferred in the year 2005, and since then the same has been pending. Having not been pursued by the appellant. Today also the appellant remained absent on call. On previous date also, that is 1/5/2024 also, the appellant remained absent. List the matter after 1 week. In the event of subsequent non-appearance, appropriate order shall follow.
Obliged, your lordship.
Much obliged, your lordship.
Same order in other appeals also.
32. Item 32.
None appears for the petitioner on call. Rest shall list the matter after 1 week.
33 and 34.
Same order, none appears for the appellant on call. Dismissal is the matter after 1 week. In the event of subsequent non-appearance, appropriate orders shall follow.
Sorry, my lord, I am saying for 32.
Already passed the order.
Item 35.
None appears for the petitioner on call. Dismissal is the matter after 1 week. In the event of subsequent non-appearance, appropriate orders shall follow.
Thirty-six. 36.
Maybe his lordship, matter may be taken tomorrow, similar matter is fixed, man. I love item number.
You are in 36.
36, man. I'm for the appellant, man. Madam here, but opposite and did not enter their appearance, my lord. We have already taken steps, my lord.
Whether service completed.
Service complete, my lord, they didn't appear, my lord, till now. I will take praise the father, my lord.
Third, Ms. Gayon, learned counsel for the appellant. Office note dated 6/9/2024 indicates that neither answer notice nor ID card issued to the sole respondent received by the section till date. Accordingly, it is provided that receipt shall list the matter after 1 week.
Yes, sir.
After 1 week. Awaiting service report upon respondent number, upon the sole respondent. Receipt shall also track the.
My lord, I am appearing for the sole respondent in the matter.
Which matter?
Riddhi Siddhi Enterprise, my lord.
Which matter?
36.
36. Acha.
My
Later
lord,
on, Mr. So-and-so, learned
question.
counsel for the.
My lord, in this matter, the question of law is covered by the full bench judgment of the Honorable Guwahati High Court, and it is a very 4,000 rupees, my lord, 4,000 rupees matter. It can be disposed of in a very admitted. They have admitted the show cause notice they have not given, and as per the full bench judgment, show cause notice is mandatory in nature.
Better way fix the next time when I'll go through the ballot judgment of this our high court matter.
My lord, a short date may be provided.
Yes,
Later on, Mr. So-and-so, learned counsel for the respondent appeared. Receipt shall list the matter on. Hearing. For hearing on 1st of October.
Much obliged.
Madam, any date except 1st of October, madam. Any date, madam.
Then 3rd October. My lord, 4th week of September or 3rd week of September, my lord. No, not in the month of October, not in September. On 3rd September. 3rd October.
Yes, 3rd.
Much
Last of this.
37.
Deputy George, my lord, we have filed a petition for delay, combination of delay, my lord. There is a delay of 431 days in preparing the second appeal, my lord. Other side has appeared and filed their objection, my lord. The appeal judgment was passed on.
What is the ground for delay?
My lord, the ground for delay, my lord, is that the petitioner, this particular appellant, my lord, is a driver by profession. So during the year 2020 and 2021, my lord, he had undergone severe financial burden and he had taken debt because he was unable to ply his vehicle, my lord. And as such, my lord, immediately after the
In which paragraph of your petition you have
My lord,
explained the reason?
Paragraph number 4, my lord. And 3 also, my lord. mainly because of financial difficulty.
So where is the document of this? Have you enclosed any medical document?
No, my medical document we have not annex, my lord.
Then,
My lord, here, my lord, para 4, my lord, is given, my lord.
no, mere mentioning in the
This is mainly because of,
application would not be sufficient.
because my lord, during that
Unless
period
there
of-
is any justification for condoning the delay.
No, no, my lord, during that period of time, my lord, because it's a driver, my lord. See, so a person who could not fly his vehicle, my lord, for a long period of time, my lord. So he was overburdened with debt, my lord. And during that period.
Yes, so what is your objection?
Objection, my lord, monetary consideration may not be the sole ground for condoning huge delay, lordship.
Why?
Well, legally service.
Unless the council is paid the requisite fees, or whether he will prepare the appeal.
Lordship, when huge delay is not properly explained, lordship, with document, support of
No,
document.
is it not a ground that his wife was suffering from ailment?
Nothing on record, lordship.
Hmm?
Only mere statement is there, lordship. And concurrent findings is there, lordship.
Pardon?
Money suit was there, lordship. Concurrent finding, lordship.
The suit was for recovery of
Recovery of money.
Money, lordship, 5 lakh rupees, lordship.
5 lakhs.
Lordship. A decree in favor of the lordship opposite party, plaintiff, lordship. I have annexed in my objection, lordship.
Hmm? When the judgment was pronounced?
My lord,
Judgment.
9/4/2021, my lord.
9/4?
2021.
Appellate judgment.
9/4/2021. And do you have the judgment of Supreme Court in Somoto case? The period which is excluded by the Supreme Court out of purview of the.
That, my lord, yes, my recently I have found there are many cases where Supreme Court has extended the delay, my lord.
So that period has to be excluded here from here.
Yes, my lord, then if it.
Hmm?
Can I use my lord? Supreme Court judge.
You produce that judgment?
Yes, my lord.
Let us fix it day after tomorrow. On the appeal being made by I. Soduri, learned counsel for the applicant. SSL list the matter day after tomorrow.
Then it may be after 16, lordship, I will be not available. Or
Pardon?
tomorrow, and then after 16. I will not be available day after tomorrow, lordship.
On 13th.
After 16, lordship.
Later, the
On 20 September.
Okay.
38. Item 38.
Please, Your Lordship. So in this matter, last year we were directed to take step on response number 8, 9, 10, 15 and 16. But inadvertently, Lordship, steps was not taken. I will take steps during the course of the day, Lordship. I may be allowed.
Heard Mr. A. Barua, learned counsel for the applicant, and also heard Miss
S. Sharma.
S.
for
Sharma, learned
respondent
counsel
number
for the
1, 2, 3.
respondent number 1, 2, 3.
Yes.
Mr. Barua, learned counsel for the applicant, submits that he could not take step upon the respondent number 8, 9, 10, 15, and 16. As per order of this court dated 30/7/2024 and price for granting and he assured that he will take step upon the aforementioned respondents during the course of the day. There is accordingly allowed recessal list of matter after 4 weeks.
Yes.
After 4 weeks. Step be taken by registered post with AD and also by usual process within a week.
Obliged.
Yeah.
39.
Hearing. You have filed 3 applications, Lordship. One to respondent by Jutika Dice, she expired, Lordship, 2019. And Lordship, we could not substitute her on time. Accordingly, the matter abated. The setting aside amendment also could not be filed on time. So there is another one application combination for delay in filing setting aside amendment. Altogether, there are 3 applications, Lordship. Basically, Lordship, it has only come to us.
You come to this IA number 696.
696 is a continuous of delay of 648 days in filing setting aside amendment petition. Basically, Lordship, it has only come to us, come to our knowledge on 28/8/2023 as per para number 5. Perhaps from the version of the opposite parties. So accordingly, on a military stage, we have Lordship done everything and filed necessary applications.
Now, you tell me whether services completed.
Office note says the services not yet
No, the
service report awaited for office note dated 31/8/2024.
Mr. Mondal, you are appearing for
We are for the 1C.
1C.
Malad.
1C, Lordship, make only see. He has already appeared. Lordship, make only see office note dated 1/8/23.
I will organize. I just absolutely. Once I see office note, I repeat it.
Heard, Mr. Your good name, please.
PKS Borough, Lordship.
Learned counsel for the applicant and Mr. Mondal, learned counsel for the respondent number
1C.
1C. Office note dated 31/8/2024 indicates that notice issued to the respondent number 8A, 8B, 8C returned with a report of the process server within bracket, oh no, within inverted comma, not found. State office note also indicates that notice issued by registered post also not returned. No, office note, state office note also indicates that notice was also issued by registered post, but neither ID card nor answered notice issued to the respondents number 8 to C returned till date. So take fresh step.
We'll take first.
The learned counsel for the applicant submits that he will take fresh step. Accordingly, it is provided that step be taken upon the said respondents within a period of 1 week from today
Lordship,
by registered post and also by usual process.
see, I have one more
Which ID?
submission to make, Lordship. In fact, Lordship, 1B, Osutos Das, he also expired, Lordship. We have obtained the legal hairs of the Osutos Das, but we does not know the date of his expiry, Lordship. If the opposite party is from the same family, if he provides the date, it will be helpful for us because we have to come to know whether it has been abated or not.
Yes, Mr. Mondal.
But I will not contact with my client, Lord, and if found, Lord, I will inform.
The learned counsel for the applicant further submits that respondent number
1B, Lordship.
1B. Respondent number 1B. Sopan Das
Sopon
already suffered demise, but the date of the said respondent is not available with him. And as such, the learned counsel for the respondent may be directed to intimate the date of the said respondent number 2. No, 1B. Mr. Mondol, learned counsel for the respondent number 8. Respondent number 8.
We are for 1C.
1C.
Yes.
1C submits that he will obtain necessary instruction in this regard and apprise this court on next day. List the matter on after 4 weeks. Peter?
Obliged.
Okay.
Lordships, that whether the arguments I had addressed in IA number 2175, whether they related to vacation of order. Well, actually it isn't, because IA 2175 I had sought, if your Lordship may just have it with us, the prayer portion will make it clear. IA 2175. At page, your Lordship may come to page 13, prayers. Because these were my preliminary objections to the maintainability of the appeal. So, if your Lordship sees prayer at the bottom, my Lord.
Yes.
In the light of the above, it is humbly prayed that the High Court may be, Honorable Court may be pleased to pass the following order. Stay order dated so and so be set aside, and the order dated 19th of April of the Court of the First Instance be restored. Now, the next prayer, my Lords, prayer B, that the present appeal may be dismissed. Now, if your Lordship also sees page 7 of the application, my Lords.
Yes.
At paragraph 4, that accordingly, in light of the aforesaid, the respondent is seeking through the present application vacation of the interim order dated 12th of June 2024 passed by the Honorable Court and dismissal of the appeal inter alia on the following ground. So, my Lords, it was for either situation, so either this or that. So, today, since your Lordship is taking up the appeal for hearing, my submission is that, as in terms of the application, these are the grounds which are also grounds for dismissal of the appeal at the threshold, because for because, my Lords, firstly, I will not repeat those grounds, but as your Lord, I will not go through that 15 out of the 21 documents were not filed, material documents conceived. Then, my Lords, continuous breach of the injunction order. And the principles of Wander versus Antox, as your Lordship has seen, already been complied. They have not been able to point out anything to the contrary. There is only one additional judgment which I want to show to your Lordships on this, my Lord. This is Ramjas Foundation, my Lord. My learned friend will just hand it over. Paragraph Ramjas Foundation. I think my India. This is on concealment only. At paragraph 21, your Lordships may come to it. Essentially, what it says that most of the judgments which are there on dismissal from the concealment of material facts are related to petitions, etc. Here, the court says, Honorable Court, Supreme Court says it is applicable to all judicial proceedings. The principle is the person who does not come to court with clean hands is not entitled to be heard on the merits of his grievance, and in any case, such a person is not entitled to any relief as applicable not only to the petitions filed under Articles 32, 226, and 136 of the Constitution of India, but also to the cases instituted in other courts and judicial proceedings. The object underlying the principle is that every court is not only entitled but is duty bound to protect itself from unscrupulous litigants who do not have any respect for truth and who try to pollute the stream of justice by resorting to falsehood, by making the misstatement, or by suppressing facts which have bearing on the adjudication of the issue arising in the case. So, it is applicable to all cases, including the present appeal. That is, so this is the fourth judgment I have cited on this point. So now, now I will come to my learned friends, Mr. Das's arguments. There is one very fundamental issue which they have not dealt with. My case is on which the plaint was instituted was disparagement and defamation. The appeal is filed only against the ground of defamation, not against the ground of disparagement. And if your lordships make, if your lordships don't mind, if your lordships may please turn to the appeal. I will take your lordship. My learned friend has also argued on the basis it is defamation. But in the appeal also, there is no ground challenging disparagement.
Yes, page number?
Your lordship, grounds, page 18, page 18. Your lordship is item grounds A, B, C, E, F, G, H. I will just show it to your lordship. Further, the impugned ex parte, I am reading ground A. Further, the impugned ex parte interim injunction does not take into account the principles laid down the Honorable Court state that the courts should exercise caution in granting pre-trial injunction, especially in defamation cases, to avoid impeding speech. No mention of disparagement. Again, the same thing in ground B, my lords. Should be reserved. Injunction should be reserved for exceptional cases, and it is in continuation of that. B is also a repetition. For that, injunction should be reserved for exceptional cases where the answering defendant is bound to fail, and that the unreasoned comments through ex parte injunctions should be avoided. I'm reading the next page, page 90. Should be avoided in the instance case that the learned trial court failed to apprehend the articles in question are fair and bona fide comment on matter of public interest pertaining to a financial matter concerning the respondent, and that the instant appellants have taken reasonable precautions to ascertain the truth. These are grounds of defamation. These are defenses in defamation. These are not defenses in disparagement. Again, in C, my lords, is the same thing, my lords. They have justified. Because my learned friend, ground C is what my learned friend had read the emails and saying they have extracted from my mail. So ground C is again a ground for defamation. And then E also, my lords. Ground E. Again, yes, ground D at the bottom. I will read the last line. The interim injunction dated 19/4/24 has been passed by the Honorable Trial Court, thereby granting a pre-trial injunction media house journalists without any discussion and finding that the contents of the impugned 4 articles are malicious or palpably false. It is swiftly submitted that the only reasoning given by the Honorable Trial Court while passing the impugned order holds that the instant application appellant published a series of publication about the respondent regarding withholding of employees and respondent's bankruptcy. Now, these are again grounds for defamation. They have not challenged disparagement at all. F also, my lords, is the same because starting off from the defamation, they have said F also is the same grounds. A, B, C, E, F, G, and H also. Same ground. I will not trouble your lordships, but your lordships may take it that G, in fact, at the bottom page of 22, it says lordships see defamation, the ground of defamation. At page 22, ground G at the bottom, your lordships, it says only says defamation. Everywhere it is only defamation, it is not, and H also, my lords, the same at page 23. So A, B, C, E, F, G, H. These are grounds of defamation. Your lordship may just make a note A, B, C, E, F, G, and H. So, my lord, they have not challenged disparagement. And I have shown the judgment, my lords, in the case of Gujarat Cooperative Milk Mart, where they have discussed disparagement. Paragraph 20 I had shown to your lordships. I will not repeat that. But there is one judgment of the Bombay High Court, my learned friend will hand over the Marico judgment, where they have discussed how disparagement and defamation are different odds, different odds. This is important. So, my learned friend will hand over. Your lordships may come to paragraph 69 in this. There is no page numbering, I'm afraid. It's paragraph 69 minutes. 69. Your lordship has it?
Yes.
So now they discuss the law on disparagement and defamation, discuss distinctly. I will read these 2-3 paragraphs, they are important because they make the distinction. The defendant has relied upon several publications and other similar literature with a view to justify the statements made by the defendant and to express that the defendant did not disparage the parachute not coconut oil. Before I proceed, it is necessary to consider the law governing disparagement of goods and the reliability of the literature produced by the defendant at the interlocutory stage. In Hindustan Unilever versus Gujarat Cooperative, the defendant therein, albeit to support a different argument other than that raised by the defendant herein, had sought to rely on the law of defamation in a suit for slander of goods and malicious prosecution. Slander of goods and malicious prosecution, my lords, is disparagement. This court observed that the legal requirements of a personal defamation case and that of malicious falsehood and slander of goods are distinct and different. The plaintiff, therefore, had also relied upon the paragraphs from Halsbury's Laws of England, the relevant paragraphs from the said judgment reproduced below. It has been rightly pointed out by the plaintiff that the legal requirements of a personal defamation case and that of malicious falsehood and slander of goods are distinct and different, and action for slander of goods, I'm sorry,
Yes.
an action for slander of goods are distinct and different. An action for slander of goods will lie where the defendant falsely and maliciously publishes words concerning the plaintiff's goods and where the publication causes the plaintiff to suffer special damages. They refer to the paragraphs in Halsbury. Now, Miller's volume 8 are in this regard relevant and reproduced below. Paragraph page 137, paragraph 274, malicious or injurious falsehood. So they discuss how this is different, and I will the Halsbury's extract. Then Miller's at paragraph. I'm skipping this part, coming to paragraph 44. There only itself. This particular extract in the middle of the bottom of the page, extracted paragraph 44. The entire contention of defendant one that the present action is in the nature of defamation as such. It is mandatory for the plaintiff to plead and prove that on viewing the impugned TVCs that the public would relate the same to the plaintiff is based on a complete misunderstanding of the nature of proceedings filed with the plaintiff. The judgments relied upon by defendant one are those relating to personal defamation of an individual or entity and not relating to slander of goods or malicious falsehood. So distinction is made. They have not challenged defamation, disparagement. The above extract from Halsbury's Laws of England cited above herein clearly brings out this distinction. This has in fact been emphasized in another judgment relied upon by the defendant number one, that is Reckitt Benckiser versus Nagal, where it has been observed as under. Now, Clark and Linson on torts draws the distinction between malicious prosecution and defamation in that defamation protects the plaintiff's reputation, while malicious falsehood protects the plaintiff's interest in his property or trade. In its chapter on libel and slander, American Jurisprudence, 2nd edition, so-and-so declared, the generally publication of any false and malicious statement which tends to disparage the quality, condition, or value of the property of another and which causes a special injury or damages distraction. And paragraph 70 is the last having clarified that the suit for defamation stands on a slightly different footing than a suit for slander of goods and malicious falsehood, which is actually disparagement, such as the present case, the scope of the law applicable to the present dispute may be ascertained. It can be observed that the criteria that the plaintiff must establish to make out a case for slander of goods and malicious falsehood and the defenses that are available for a defendant in such a suit are distinct from a suit for defamation. The judgments relied upon parties shall be viewed in this context. In order to make out a case for disparagement, slander of goods, disparagement / slander of goods, the plaintiff must show the following: that the defendant's statements are false, that the statements were made and published maliciously, restlessly, the said statements cause special damages to the plaintiff. Now, on similar lines, I have also, my learned friends will give your lordships the Black's Law Dictionary. They have also made a distinction between defamation and disparagement. So now then I think by the time it comes, yes. Your lordships may see the second page, defamation, bottom, second bottom. The act of harming the reputation of another by making a false statement to a third person. If the alleged defamation involves a matter of public concern, the plaintiff is constitutionally required to prove both the statement's falsity and defendant's fault. A false written or oral statement that damages another reputation. Now your lordships may come to the next page, disparagement. Bottom, again bottom right. Your lordships have point number 3 in disparagement. Just mark it. A false and disparagement of, I'm reading point number 3, a false and injurious statement that discredits or detracts from the reputation of another's property, product, or business. To recover in tort for disparagement, the plaintiff must prove that the statement caused the third party to take action, resulting in specific pecuniary loss to the plaintiff, also term malicious false. So, the distinction has been made between defamation and disparagement, which my learned friends have not appealed. Now, if I may then take your lordships to the pleadings in the plaint and the judgment, impugned judgment, where we have pleaded it. They are two distinct torts. 0.3, my lord.
Mr. Hazoika,
Huh.
this third page,
Yes, my lord.
where it is mentioned about disparagement.
Bottom right. Bottom right. Bottom right. Right hand side bottom right.
It is not available in this page.
Third page. Oh, your lordship. The last page, your lordship. I don't know what.
He had given only 2 pages.
Oh, I'm sorry, my lord. I'm sorry. My learned friend will give it in, my lord. I'm sorry. I didn't realize. That was turned in photocopy. My lord. I thought I don't know. He will give it in, my lord, before the end of the date. But your lordship may take it. They made that distinction, which I already did from your lordships. They will give it. I'm sorry, my lord. This is a confusion. Then, my lord, now, if I think third page, your lordships may see.
Yes, got it.
Yes, sir. Point number 3.
Yes.
I'm ready. I will read it again, my lord, for your lordship.
Yes.
Because this is important. Blacksmith is an authority, and it's a very nice, succinct definition. A false and injurious statement that discredits, point number 3, a false and injurious statement that discredits or detracts from the reputation of another's property, product, or business. To recover in tort for disparagement, the plaintiff must prove that the material statement caused the third party to take some action, resulting in specific pecuniary loss to the plaintiff, also termed injurious falsehood. So, two distinct torts, defamation and disparagement. And I have pleaded it. Now I will take a lordship to the plaintiff.
So, your contention is that the judgment referred by Mr. Das are not applicable here.
No, I'm not saying they're not applicable, because there are two bases on which I have proceeded. One is the tort of defamation, the other is the tort of disparagement. The appeal has been filed only as respect of defamation, not regarding disparagement. And their arguments have also been only on defamation, not on disparagement, which is a distinct, and which is the finding of the trial court also. Apart from my pleading, my lords, in the plaint, it is also the finding in the trial court. They have said it has gone on the basis of disparagement. Because defamation affects my reputation. But disparagement is a tort which distinctly affects my business reputation. Not only my business reputation, it causes a pecuniary loss to me. That is the distinction which they have. So they have only appealed against one part, they have not appealed against the other part, and which there is a finding by the trial court, and which I have pleaded. That is my submission, most respectful submission.
Yes.
So, my lord, if your lordship will just come to my plain page 46 of the appeal. Page 46, I have taken the plea, my lord. Appeal paper book, page 46. This is a plain, my lord.
Yes.
So, paragraph 20.
Yes.
20, 22, 21, 22, your lordship will see 21 bottom, second last line, defamation and disparagement. Then again, paragraph 22, fifth line, disparaging the plaintiff's business. So then, my lords, again in paragraph 25 to 32. My lords, fourth line, the lordship will see defamation and disparagement.
Yes.
Then again, 26, my lords, fifth line, defamation and disparagement. Then 27 again, my lords, it is there, 27, first line itself, defamation and disparagement.
Yes.
Again, my lords, that paragraph 30, page 51 bottom. Paragraph 30, page 51, second last line, defamation and disparagement.
Yes, got it.
And paragraph 32 also, my lords, defamation. So everywhere it is there. So since I have pleaded it, it is therefore, and then your lordship, the impugn judgment, impugn order, page 81, your lordship. Your lordship has page 81, impugn order, my lords, page 81.
Page number?
81.
Yes.
Now, if your lordship sees the fifth line, my lords, I will just read from the middle till the 1, 2, 3, 4, 5, 6. Proceeding from posting, publishing, or circulating any posts that amount to disparagement of plain itself services, as immediately take down the impugn articles or any other similar articles or the post write-up or material relating to these impugn articles. So disparagement is the basis on which the learned trial court has proceeded. So, my lords, having said so, my most respectful submission is that they have therefore filed their appeal and also their arguments that only on the ground of defamation, they have not urged disparagement at all. So, therefore, the findings on disparagement are unaffected, and therefore, my lords, they hold, and therefore, my lords, this is one ground which goes against. So now, my lords, I have taken your lordships to these judgments. Now, my lords, I will take your lordships to the contentions of my learned friends and then respond to each one of them. Now, the first contention of my learned friend was that prior to the publication on 12th of March 2024, they had put those articles to me, so that I had knowledge, and they asked for my comments, and I could not, and therefore, since it was put to me, therefore, they escaped any liability in this regard. Now, my lords,
yes,
and in this regard, my learned friend relied on that email which gets sent at 7:38 a.m. in the morning. And I've written that in the mail, and I will take that to your lordship. At 7:38 a.m. they send it to me. My office is open at 10 o'clock. And they say we are going to publish it by 11, maximum we can hold it 12 o'clock. Then they, even in breach of their own assurance, they publish it at 11:15. I respond at 2 o'clock. So it was only for the sake of compliance and the sake of any kind of, it was not a substantive requirement of showing to me, because if that article had been ready, there are 19 queries. Your lordship will come to page 87 of the appeal. My learned friend that showed that to your lordship. I would like to show your lordship that again.
Page number
85, my lords.
Yes.
Your lordship, my learned friend had shown this repeatedly to your lordship. Sent your lordship will see Mansi Verma at the top left, 12:38, 12th of March 2024, 7:38. Your lordship sees that now. Your lordship.
Yes.
So this was my. There are 13 queries. Now the 13 queries, they say, what do they say? At page 87, your lordship may come. Top. Since this is a breaking story, it will go up by 11 a.m. latest. We will be willing to accommodate the company's comments in that story till 12 p.m. on March 12th. That is the same day. So you are sending me a mail at 7:38 in the morning when my office is open at 10 and saying that it will go up by 11, latest by 12, you can hold it, you give your comments. How can I respond to 13 queries when my office is open at 10 and people don't even open their emails? And this is what I've said, and this is what was not read out. My learned friend read out part of it, but he didn't read out the first two paragraphs. Next page, your lordships may come. Page 88. My response. Ms. Mansi Verma, this is I now write your lordships on the same day. Your lordship will see top left at 2:34, because it takes time for me to get the thing together. I deeply appreciate you reaching out to us to verify the information. However, the time given was very less. Our office opens at 10 a.m. and we can't access and respond to all mails immediately. Though you gave us time till 12 noon, but you published a story at 11:15 a.m. It seems you had already created the story and were predisposed to writing it. Shouldn't you have given us adequate time, waited for a response, and then create the story? What was the hurry? How will this story serve the purpose of the interest of the student community or education in general? Then next paragraph. We hope that your investigation is deep and that not only the facts are correct, but your narrative is aligned with the true intent of what we are doing at FIITJEE. What will our employees gain by twisting facts and converting them into rumors that will harm their own careers? Third paragraph. We know who's fueling these stories. These are the butchers of Kota who are trying to expose in the interest of society. Money Control is a great company and you must join hands in stemming these 3 sets. So, my lord, first 3 paragraphs I will tell them that you have not given me any time. So he says, I put it to you. He put it to me. But is this the manner of putting it? At 7:30, 8 o'clock, nobody reads mails. We're not in the office. Now, my lords, if I may take your lordships now to the second contention. He has said, my learned friend submitted that the contents of the impugned articles were based on emails, respond on the response, and factually correct, that there was no factual inaccuracy. Now, my lords, your lordships may, he has read out only parts of this. The whole thrust of the impugned articles was to suggest that the respondent was suffering heavy losses and would go bankrupt, linking the alleged non-payment of salaries to alleged financial difficulties, suggesting that the respondent was performing poorly financially with reference to Byju's. Now, Byju's is another institute which has financially collapsed. They collected a lot of money and then they stopped giving services. It is relevant that Byju's, one of the biggest institutes, that financially collapsed. You'll actually come to page 99. On one hand, they are saying this, no employee has made a grievance. Third paragraph, your lordship, basically page 9. This is the same email which my learned friend that this is the same article, the first impugned article. To be sure, your lordship may skip the third paragraph. To be sure, this follows a fiscal year when the test prep organization slipped into losses after generating small profits in FY22. As per data from TrackXN, the company has been recording negative cash from operations for about 8 of the past 10 financial years. In addition, FITG's revenue scaled down by about 23% from rupees 615 crores in financial year 22 to rupees 475 crores in financial year 21 and has been trending around this number since. In financial year 23, while the company experienced a 21% increase in scale to rupees 542 crores from 448 crores, its reported loss of rupees 69 crores against profit of rupees 37 lakhs in FY22. Every one of our staff must be aware of the next page. I will read page 100. Every one of our staff must be aware that most of the Akash's Institute franchise were possible until the Akash Institute was acquired by Byju's. Why were they profitable while our centers were burning money? Now the reference is to Byju's, saying that Byju's, because Byju's is one company which has collapsed. So if you are parting an article, say, correlating this to me, this is the financial bankruptcy, and which is the finding of the learned trial court. That is my most respectful submission. Then, my lords, your lordship may come, my lords, to page 102 of the second impugned article. The second impugned article at page 102.
Yes.
Well, it is nothing but a series of so-called opinions. We don't even know whether these are opinions or facts or whether they are self-serving. So even opinions are defamatory, my lords. Because if it is one-sided opinion, a whole series of opinions, no employee has today raised a grievance. There is no non-payment of salary. It was a financial restructuring, and we made that environment in the field as a finding of the trial. They have gone on, and done this. And the third, my lords, your lordship, they have my learned friend, which they have not filed in the appeal, but which is at page 68. Your lordship may see. In the appeal, they have filed it. They have referred to it.
At page number
68. It is in my plaint, actually. Because they don't even refer to it in their appeal. It is in my plaint. I'm sorry, mother, it's in my plaint. Now, it is that portion in Hindi and the middle, your lordship will see.
Yes.
Essentially, what it says is, in Hindi, is that it is a wrong to ask for salaries in Fiji. The founder has given such a response that it has broken the hearts of the employees. So if that is not defamatory, what it is? It is in Hindi, and that has a greater sensational content. They have not even, this is one of the concealed articles. This is not filed. And the fourth one, my lords, is is at page 112. I will not trouble your lordships. It is on another unrelated subject at 112, relating to some advertisement. So, my learned friend has shown those articles. I don't want to trouble your lordships with that. My only most respectful submission is that in the space of 6 days, they publish 4 articles. Money.control.com is one of the biggest news websites. They have 5 lakh subscribers. Well, I have said so in the play. Which means that any article which goes up there is seen by 5 lakh subscribers, and those people like us also who are not subscribers can view it. So that is the spread and content of it. So what was so so venal about Fiji that you have to write 4 articles in 6 days and destroy my reputation? Now, my lord, if I may take, my learned friend has relied on, my lord, in the annexure 12, 13 and 14 of the appeal. I will just tell your lordships the pages. 12, 13 and 12, 13, page 120.
Yes.
Page 120 is annexure 12. These are articles of which are not part of the record below. 12. Annexure. I'm sorry. Lordship has it. 120. Your lordship has 120.
Yes.
120. This is our business today. Then now, your lordship, may I just pause for a moment and make my submission. Annexure 12, 13 and 14 are not part of the record below. These are articles published by others, or one article and one single stray comment by someone or the other, published by others, which my learned friend submission is that if others have written, why can't I write? But nobody has mounted a campaign, and these are not part of the record below. So they cannot be annexed. And if I may, my lord, point out a full bench of the Allahabad High Court, my lord, to your lordships in this regard. My learned friend may hand over, my lord's Zila Parishad Badao and others. In this case, what happened, this issue was referred to a full bench because whether material which was not part of the court below in an appeal against ex parte injunction. This is a similar case in an appeal under ex parte injunction. Can you file new documents in appeal without taking leave under Order 41, Rule 27? Page 19 is the answer. Paragraph 19. Your lordship will come to paragraph 19.
Yes.
On a review of the authorities mentioned above, the 11 provisions of Order 39, Rules 1 and 2, Order 43, Rule 1 CPC, we are of the opinion the case of Meston School Society versus Kashinath Mishra lays down the correct law on the point, and that the case of Raja Dev Singh Kumar versus so-and-so does not lay down the correct law. Read question number 2. Ordinarily, an appellant is confined to the evidence already and record prepared by the law court. It is open to him to request the appellate court to admit fresh evidence under Order 41, Rule 27. Where permission is granted and fresh evidence is admitted under the aforesaid provision, the appellant can rely on the evidence. Learned counsel of the appellant has not been able to cite any authority to show that an appellant as of right can rely on fresh or additional evidence in appeal from an ex parte order passed under Order 31, Rule 1 and 2. So annexures 12, 13 and 14 cannot be even seen by your lordship because these are not part of the court, and he has not filed an application under Order 41, Rule 27. 12, 13 and 14. Annexures 12, 13 and 14. So these cannot therefore be looked into. In view of this judgment, because if they have to file, then they have to take a plea under Order 41. They have to file an application under 41, Rule 27, which they haven't. So now, my lords, I will take your lordship to the next contention. And in any case, my lords, these are one article is a tweet of one individual. It's one single article, and there's neither here or there, my lords, in that. It is not the nature of campaign which my learned friend has run. Now, my learned friend has admitted, his fourth contention, that the prima facie case has been made out. He has admitted. He has said that the prima facie case is made out. But grounds of balance of convenience has not been, because my learned friend admitted whether your lordship's query. Now, if the concession of the appellant at the time of the argument is that a prima facie case is made out, then it shows that an injunction has to follow, because it is a case of both defamation and disparagement. He has not been filed against disparagement. So, if a prima facie case is made out, then an injunction has to follow. Because the balance of convenience would not be in a case like this, that an article like this is available for 5 lakh of the subscribers and further posting on social media, because this is shared also. It will go on to Twitter, it will go on to Facebook, it will go on to Instagram. Because when your lordships are asked, Mr. Das had said, yes, I give you a prima facie case may be made out. But he had said that with the balance of convenience is not there, but he had not substantiated. Now, the fifth contention is that my learned friend is that taking down of the article would imply an ad interim mandatory injunction. And he says an ad interim mandatory. He has cited that judgment of Tek Singh,
Yes.
I have seen, my lords, it does not seem to be a ground in the appeal in the first place. In any case, apart from that, my lords, taking my learned friend has cited that, paragraph 7, I think he had cited. As to my learned friend has cited that, paragraph 7.
Yes.
Paragraph 7, the learned counsel appearing for us, argued before us such an attempted to support the judgments. He has argued from the extract, paragraph 16. The relief on interlocutory mandatory injunctions are thus granted generally to preserve or restore the status quo of the last non-contested status which preceded the pending controversy until the final hearing, when full relief may be granted, or to compel the undoing of those acts that have been illegally done, or the restoration of that which was wrongfully taken down from the party complaining. But since the grant of such an injunction by a party who fails or falls or would fail to establish its right in the trial may cause grave injustice or irreparable harm to the party against whom it was granted, or alternatively, not granting of it as a party to who succeeds or would succeed may equally cause great injustice or irreparable harm, also involve certain guidelines. Generally stated, these guidelines are: the plaintiff has a strong case for trial, that it shall be for a higher standard than a prima facie case that is normally required for a prohibitory injunction. It is necessary to prevent irreparable or serious injury, which morally cannot be compensated in terms of money. The balance of convenience is in favor of the one seeking such relief. So now, my first submission and only submission is that this is not an interim mandatory injunction. In the nature of the internet today, when an injunction order is passed, restraining circulation, if your lordship sees a newspaper or an article which was published, it is published on physically, and it goes out. Any restraint on publication means that they cannot republish it, whichever media house it be, whether it is a book or it is a. But in the case of the internet, it is up there. So if that article is up on the website, available to viewers, the only way an effective injunction can be passed is the article to be taken down. In any case, it is not a mandatory injunction, because if the circulation of the article has to be stopped, consequences that the article has to be put down, or they have to blank it out. It is not a mandatory injunction. One. Two, in any case here, those who have downloaded that article and circulated it, it will be available. So it can never put me back in terms of the test of interim mandatory injunction as to restoration of status quo ante. It will never be that position. But it will still be available. What happens is, if anything is up on the internet, it is up there. Now, it can also happen that if I click on it, I can download that article. It will be independent. And then I can share it across different forums and share it across WhatsApp groups. I can send it to anyone, like a judgment, but up on the website. Once it is up, if it is downloaded, even if there's the website of the Melons, assuming that there's an injunction against the High Court website, the judgments, but those who have downloaded the judgment copy, they will be able to circulate it. So it is not a mandatory injunction putting me back to restoring status quo ante. This is only restraining the circulation of that article, because the only way an effective injunction order can be passed is by pulling it down. Other than it will be otiose. Now,
yes.
Now, his next contention was that there is a delay on my part in approaching. Now, 25th of March was when Digitup wrote to me. That article was still up. I wanted to file. We approached, and because the High Court and the trial court may have been open, but the lawyers were not available. In any case, the delay doesn't matter here, because because today if that article is up there, every day is a cause of action. It is unlike a physical publication of a newspaper or a book, which once it is circulated and it goes out, and unless it is republished every day. Here, 24 hours, 7 days a week, that article is up. So every moment is a recurrent cause of action. Every moment there is more cross-posting on social media. Every moment there is a new viewer, there is a new whatever. So, the kind of campaign which they did, and the manner in which continuing harm it caused on a daily basis and on an immediate basis, that the delay cannot be a factor in this one, because it has been there. It is continuing harm at every point of time, because it is up there available to all viewers. And it was posted on social media, people were commenting. So every moment is a cost. I have shown those, I will not trouble your lordship, but I have shown from the plaint where we had filed. Those documents were on social media, comments continued to be made every day. So there is no delay, because every moment is a new cause of action. So now I will take my lordship to what my learned friend has cited, the judgments. He has cited the case of Bloomberg. I think your lordship, I may point out if your lordship sees the bench here, my lords, if your lordship sees the quorum, my lords, your lordship may see who the judges are. Actually, Chief Justice Chandrachud, Justice Pardiwala, and Manoj Mishra. The same bench which passed the order, my lords, in our case. Your lordship may see page 15 of IA 2175. Page 16. Same judges.
Yes.
Yeah. Same Chief Justice, Justice Pardiwala, and Justice Manoj Mishra. The same quorum was there and here. So, the judgment which was rendered, obviously, they were cognizant when they passed the judgment which they did. I mean, everyone is expected to be cognizant, and they were particular. But in any case, this judgment does not apply. You'll actually come to paragraph 3 of the judgment. Because this was a case of an unreasoned order, and this was a case of defamation, not disparagement. The order of, I'm reading paragraph 3 now. The order of the trial judge indicates that the discussion after recording the submission of the respondent commences at paragraph 7. The only reasoning which is found in the order of the trial judge is in paragraph 8-9, which reads as follows. I have noticed that in Dr. Abhishek Manu Singhvi's Supra, Chandra Kocher's Supra, Swami Ramdev's Supra, ex parte and an interim injunction was passed considering that the contents of the material in question was per se defamatory. In my view, the plaintiff has made out a prima facie case for passing an ad interim ex parte orders of injunction. Balance of convenience is also in favor of plaintiff, and against the defendant, an irreparable loss and injury may be caused to the plaintiff if the injunction as paid for is not granted. In view thereof, defendant number 1 and defendant numbers 2 are directed to take on the articles dated so and so from online platform within 1 week of receipt of this order. The defendants are further restrained from posting, circulating, or publishing the aforesaid article in respect of the plaintiff on any online or offline platform till the next date of it. Now, they discuss it at 11 and 12 because this is an unreasoned order on the face of it. Paragraph 11. The court has occasion to deal with it. So this was an unreasoned order, which is not in my case. There has been a whole discussion. They are saying there is bankruptcy. They are saying that one franchisee has used paragraph 11 and 12. I will read. In the order of the trial judge, does not discuss even cursorily the prima facie strength of the plaintiff's case, nor does it deal with the balance of convenience or the irreparable hardship that is caused. The trial judge needed to have analyzed why such an ex parte injunction was essential, and after setting out the factual basis and the contention of the respondent made before the trial judge. The trial judge merely states in paragraph 7 and 8 that the court has gone through the record available on date and noted certain precedents where an ad interim injunction was passed without even cursorily dwelling on the merits of the plea. The ad interim injunction granted by a trial court amounts to unreasoned censorship which cannot be counted. Undoubtedly, the grant, I'm reading paragraph 12. Undoubtedly, the grant of an ad interim injunction is an exercise of discretionary power, and the appellate court will usually not interfere with the grant of interim leave. However, in a line of precedent, this court has held that appellate court must interfere with the grant of interim leave at the discretion which has been exercised arbitrarily, capriciously, perversely, or where the court has ignored certain principles of law regarding regulating the grant or refusal of interlocutory injunction. The grant of an ex parte injunction by way of an unreasoned order definitely falls within the above formulation necessitating interfering by the High Court. This being a case so much, it was an unreasoned order. It has nothing to do with my facts. And in any case, this is only defamation, as I pointed out to your lordship. So I will not trouble your lordships with the impugned order, but the impugned order very categorically renders findings of financial insolvency, bankruptcy, circulation, and how the franchisee or proposed potential franchisee has withdrawn. Now, he has tried to distinguish judgment I have cited in the case of Prestige Lights, which is already there. I think my learned friend will. I had earlier cited Prestige Lights, if your Lordship will recall. You can hear me. And he has relied on paragraphs 8, 22, 23, and 26. Now, I will take a lordship to paragraph 26. This is a judgment which I have cited in my favor, which is paragraph 23. I will not trouble your lordship with that. But he has cited paragraph 26. Your lordship already has an earlier copy of this. But I am giving it just for the sake of convenience, so your lordship is not troubled. Paragraph 26. This, however, does not mean that in each and every case in which a party has violated an interim order has no right to be heard upon. I'm reading paragraph 26. Nor will the court refuse to hear him in all circumstances. The normal rule is that an application by a party will not be entertained until he has purged himself of the contempt. My learned friend today has admitted that what is the purpose of filing the appeal if I take down the articles? What is the purpose? And your lordships may know that I have filed an affidavit of 7th of June 2024, which is, your justice may just make a note. It is 7th of June at page 151. 151 in the appeal, your lordship may just see. Where, my lord, 7th of June 151, where, my lord,
Yes.
I have shown that this I have shown, my lord, that page 151. This is the affidavit which I filed on 7th of June 24. They have not filed any response to it, where I have shown all the injunction violations, breaches, contempt, and everything. So the paragraph 26 on which he says supports him in Prestige Lights goes against him because he has to purge his contempt. He has till date not purged his contempt. He did not purge his contempt on the day he filed the appeal. He did not purge his contempt on any of those dates when I filed this injunction, this affidavit on 151. So, the reliance on this judgment, which he says in his favor, I don't understand. It is misplaced in my most respectful submission. And the last submission of my learned friend was, that he has relied on a judgment in the case of Modern Food Industries, 2000, I think it is 1995 Supplementary 4 SCC. Though he did not read it out, but since it was cited at the bar, I am simply relying upon it. This is at paragraph 4, the facts are there, but this is an entirely different case. Here was a case of an appeal being filed and the contempt being proceeded with when the appeal was being heard. The Honorable Supreme Court says that when the appeal is being heard, why are you proceeding with the contempt? That's also, it has no application to our case. I am not today pursuing that contempt. But today my submission on contempt is on a different ground. On the ground of Prestige Lights, paragraph 23 of Prestige Lights, which your lordship has seen earlier. I will not trouble your lordship with that. That if he is in breach, and the Justice of Justice Sanjeev Khanna, when he was in the Delhi High Court, I have cited 2 judgments relying on Prestige Lights, saying that if they are in breach, they should not be heard. And Justice Khanna in the High Court had also imposed penalty and cost. That judgment I had cited at the open. So my most respectful submission was I have now more or less done with whatever has been submitted. So my most respectful submission is that on the 3 preliminary grounds, first is material concealment, suppression. Secondly, breach, continuing breach, non-compliance of the impugned order. And thirdly, on the principles of Wander versus Antox, that these appeal has to be dismissed at the threshold, which I have urged in my application at 2175 and also in my submission before your lordship. The appellants have not filed a response to any of either the application or the affidavits I have filed. And as far as on merits is concerned, I have demonstrated as to how none of their submissions are meeting. I am concluded, I'm grateful to your lordship. And if
So we reserve the order.
I'm grateful. I have only one request, if your lordship,
Yes.
for your lordship's convenience, can I put in a brief note of submissions on what I make tomorrow?
Yes, yes, you can.
I'm grateful.
My lord, my senior is on probably in other court, my lord.
Pardon?
My senior is probably in other court, my lord. And just allow some time to, my lord, only just some time. Lordship may take up some other case, my lord. In the meantime, he will respond to all this. Just we will require only 15 minutes, nothing more than that.
I have given him all the judgments also, my lords. Now, why can't my learned friend argue himself?
So when do you want then?
Well, let me call him, my lord. He may be in some other court. He will
Today at about 4 o'clock then, after 1 hour.
My lord.
Okay, okay.
Always.
Grateful.
Okay, Mr. Africa, we'll take it up at 4 o'clock.
I'm grateful. I agree.
Timing item number 4.
May I please your lordship? Lordship, the impugned order is at page 60. By this impugned order, lordship, and by this impugned order, lordship, and civil Nazir has been appointed as commissioner to inspect the.
So what wrong with that order?
Lordship, kindly peruse the prior portion of the title suit, lordship. In their title suit, they have sought for declaration of right title interest and recover and by evicting the defendants, their agents, and their employees, and also sought for cancellation.
Yes.
Also sought.
The lordship permission. Here we have challenged an order passed by the learned trial court under order 26.
No, that's why I'm asking him, what wrong with that order passed by the learned trial court?
My lord, I'm coming to that. My lord, normally an order passed under order 26 rule 9 for elucidating the dispute, it is necessary. But here is a case, the dispute is not about whether there is any rented house or not. They have claimed, my lord, two things. Plaintiff has filed the suit, your lordship, whether my learned friend has given the background or not. It's a case, I'm just giving the background. Property originally belonged to one Mr. Chaliha. He had 3 sons. One son, after his death, all the 3 sons have equally inherited the property. Third son has sold the entire, his share of property to us. I'm representing one of the sons, legally as of one of the sons. Now the other sons, wife and daughters, they have filed a suit because all of them are staying in UK. They are not staying here. And they have filed a suit praying for a declaration of right over their share of the property. First. And second, there is an agreement to sell that they are themselves are saying there was an agreement to sell by which we have paid 15 out of 30 lakhs, we have paid 15 lakhs to them. But somehow the sale deed was not executed. So they have prayed for cancellation of the sale deed also, agreement to sell also. This is their second prayer. And their third prayer is for partition, preliminary decree, etc. Now, this is there. This will be decided in the trial. Now, they have filed a present application on the ground that there is a house, which they say that there is a house constructed by the father. There is original Chaliha, my original owner. And there is a tenant there, and we are not disclosing the name of the tenant. Lordship, we have filed a reply saying that the original house constructed by the original owner has been demolished and we have made a new construction. So dispute is, my lord, not whether there is any tenant or not. Dispute is who has constructed. If we say that we have taken a specifically that we have dismantled the original house and we have constructed. So the structure which is existing now, we are claiming that this is structure constructed by our father. That is the son of the original owner, whose legal heirs we are representing. And there are two things. One is, if the house was originally constructed and remained there, then the question comes, if a question comes whether there is any tenant or not, there may be a necessity of my lord finding out whether there is any tenant or not by an order passed under Order 26 Rule 9 and appointing a commission. But when we say that the construction is there, we are not disputing whether there is any construction or not. We are saying that we have demolished the original house. Lord, shall you kindly see, this is the area where I'll be arguing. Lord, shall you kindly see what is the stand taken by them. Thereafter, I'll come to the appeal order. Page 15, para 7, my lord. Apparently, it appears that it's a very innocuous order only for elucidating the controversy, whether there is any tenant or not. But question is, what is the dispute? This dispute cannot be settled in my humble submission by a commission. I'm coming to that. My lord, may I kindly see page 15, para 7. This is paragraph 7 of the plaint.
Paragraph 15.
Para 7, page 15, madam.
Yes.
That the plaintiffs submit that they have been residing in the United Kingdom since the days of their husband, father, late Apurva Kumar Saliha, and frequently visited India, Assam to meet their relatives and also to look after the suit property described in the Schedule B below. Plaintiffs further state that their predecessor during their lifetime had constructed RCC and Assam type house. There is only one house. Originally, it was only Assam type, but somehow they have said RCC and AT Assam type house over the suit land for residential as well as commercial purpose. It is to be mentioned here that the premises constructed for commercial as well as residential purposes was let out to some tenants on monthly basis since the days of their father. Defendants have been residing in the premises standing over their respective share of the land, measuring 1 biga, 1 kata out of Schedule A below, covered by so-and-so, so-and-so. And to that effect, the plaintiffs had no claim. This is their next paragraph also is slightly important, page 16. That the plaintiff state that they orally authorized so-and-so, now this is son, husband of so-and-so, to let out and receive house rent and look after the suit land and premises described herein below, and also to pay land revenue and other taxes to the government for and on behalf of the plaintiffs. In fact, said Ananya Madhav Saliha, son, husband of the defendant number 1 and 2, had been collecting the house rent from the tenants in respect of the commercial as well as residential rooms in each calendar English month, and said Ananya Madhav Saliha had been paying collected house rent to the plaintiffs till the year 2012. This is their claim with regard to this house. Now, Lord, may kindly see what is our reply. Lord, may kindly turn to page 30. It is paragraph 10 and 11 of the written statement where we have replied to their statements made in paragraph 7 and 8. Page 30, my lord. Para 10. That the statements made in para 7 of the plaint are not admitted by these defendants and as such denied except the fact that plaintiffs have been residing in the United Kingdom since the days of their father or husband. No building of RCC and AT house constructed by their predecessors over the suit land for the commercial as well as residential house are existing, and there's a typing error, are existing as alleged by the plaintiffs, and so no question of alleged buildings have been let out to some tenants on monthly basis since the days of their father arises at all. Lord, shall you kindly see this reply. The old residential building constructed by the predecessor of the plaintiffs and defendants has been dismantled long years back, and the husband of the defendant number 1, namely Ajoy Madhav Saliha, since deceased, had constructed new building over the suit land, defendants have been residing in their own house constructed by Ajoy Madhav Saliha and Ananya Madhav Saliha. The statements made in paragraph 8 of the plaint are not admitted by these defendants and as such denied. There is no rented house of joint property of the plaintiffs and defendants constructed by their predecessors as alleged by the plaintiffs. So no question of authorizing Ananya Madhav Saliha since deceased to let out and receive house rent and look after suit land and premises described in the schedule of plaint arises. And next page also we have clearly said same paragraph, my lord. So question of collecting rent from the tenant in respect of commercial as well as residential room doesn't it?
No, Mr. Majumdar, you saw how prejudice is caused to you by this or impugned order?
My lord, normally no prejudice will be caused to me. But here is a case, my lord.
So admittedly, the property is a joint property.
Property
It was
land
not
is joint.
partitioned.
My lord, land is joint.
Yes.
So far as house is concerned, my lord, they said that there was a house where our father let out the house to some tenants. We have said that original house we have demolished.
No, not only the house, one ATM is also there of Punjab National
But
Bank.
I'm coming to that. That is why I'm saying, my lord, we have admitted that there is a house. Now, appointing a commission for the purpose of determining tenant, etc., is not necessary. Why, my lord? Controversy is not whether a house is existing or not. Controversy is who has constructed. Now, my lord, if they say that there is a tenant and we are entitled to rent from there.
No, whether at the time of construction the permission from permission of other stakeholders were obtained.
My lord, 10 years back, an agreement to sell was executed in our favor, admittedly, my lord, and they have prayed for cancellation of that agreement, but they have taken 15 lakhs already, and we are ready to pay. My lord, we have given the details in the written statement as to till 2021, how the development, as in when they came, one person died, and then we offered the balance amount. They said, no, let us come back again from UK, then we will see. This way, the agreement to sell is in progress. We have been paying the money, they will sell it. In such circumstances, my lord, where is the question that they should collect rent and we should not collect? My lord, my submission is very simple. What I am saying is, my lord, if there is a house and if you say that I am entitled to mean profit in the plaint, my lord, then there is a necessity of ascertaining today that how much rent he is collecting, who is the tenant there. Lordship may kindly see their prayer. What is their prayer in the plaint?
No, maybe, but subsequently they have filed one application upon which one mistake case was registered and the order was passed.
My lord, I am not on that. What I am saying is, my lord, what is to be founded by the Order 26 Rule 9 order, my lord? Controversy is not about the house is existing and rent is being collected, is not the controversy. Controversy raised from the pleadings of both the parties is who has constructed. We said that we are admitting that there is already a house, RCC house, but we have constructed. They will have to prove that they have constructed the house, my lord. We will show that we have constructed. They will have to show that old house is still existing. Now we are admitting that there is a RCC building standing. Only thing is we have constructed. Now, in order to decide as to who has constructed, my lord, evidence is necessary to show that who has constructed. For that, a spot verification will not determine, my lord. Evidence from a commissioner.
No, commissioner is appointed only for limited purpose.
My lord.
So who are the tenants?
My lord, that is what I am saying. Supposing there is a tenant also, how it will help in the trial of the suit? That is why I said, my lord, what is the controversy? If the controversy is that there is a boundary dispute, I am saying that I have not encroached, and somebody says he has encroached, then there is a necessity of finding out that where is the boundary line, whether there is an encroachment. Here, there is no such dispute which is required to be determined by.
Okay.
My lord,
we'll issue notice.
My lord, what I am trying to show you, lordship, is the actual controversy which is required to be decided in the trial of the suit cannot be done by way of this commission, my lord, because who has constructed?
No, this I have already told you that this order is passed in Mizje case, which was registered on the basis of one petition number 1040 of 2024.
Yes. My lord, that is what I am saying, that petition which has been registered as 1024 is a petition filed by the plaintiff
Mm.
under Order 26 Rule 9,
Mm.
praying for Lordship will kindly see their petition.
Mm.
Page 54, my lord. This is the petition. A two-page petition, my lord. My lord, if they say that I am entitled to mean profit, and now it is necessary to find out how much rent you are getting, then it's all right.
Mm.
In this suit, they have not paid for any mean profit. They are asking only for partition, and they know that there is a new construction.
Mm.
Lordship will kindly see their petition, page 54.
Mm.
That in the above case, plaintiff petitioner had filed an application seeking direction that the defendants be directed to disclose the names of the tenants falling under the suit property. But after service of copies, the defendant's opposite party is disputed and denied the existence of any tenant over the suit property. Then next page, that the replied filed by the defendant opposite party are wrong, incorrect, inasmuch as there is an ATM of Punjab National Bank operational over the suit property amongst other rental property to the best of the knowledge, and as such, it has become incumbent on the part of the plaintiff petitioner to get the survey done through a commissioner who be appointed by the court so that the actual picture of the suit property after being verified by the commissioner so as to enable the court to come to a just decision. As such, it is humbly prayed that the honorable court may be kind enough to appoint a commissioner to find out and ascertain the names and address of the tenant who are in possession of the suit property, Schedule A property as described in the plaint, along with the amounts paid and amounts being paid as rental income and the tenure, and submit the same before the court. Now, this petition would have been a very relevant petition had in the plaint they sought for a decree that we are entitled to mean profit. Lordship may kindly see their prayer. What do they want? Well, page 43, Lordship may kindly see. It is not their case that, see, you have let out the property and you are monthly getting 10,000. I am entitled to a share of it.
Mm.
Then there is a necessity of ascertaining who is the tenant and what is the rent being paid, because they want mean profit. Lordship may kindly see page 43. Decree, this, I'm sorry, this is page 22, I'm sorry, this is our counterclaim. Page 22, my lord. A decree for declaration of right title interest of the plaintiff over the suit land described in Schedule B below and for recovery of same by evicting the defendants, their agents, tenants, etc. Then decree declaring that agreement for sale dated 6/6/2012 is illegal, contrary to the provisions of law, etc. Then, my lord, paragraph thereafter, a decree for partition of the Schedule A land below and also declare the plaintiffs are entitled to get separate possession and recovery of possession of the land measuring 1 biga 1 kata, and then preliminary decree. Then we filed written statement come counterclaim, and there we have prayed for this decree. Lordship may kindly see at page 43. What is our case? They have not prayed for any mean profit that you have earned. You are earning rent.
No, since the property has not been partitioned,
My
whether they have no interest over the same.
My lord, my submission before Lordship, they have an interest.
Mm.
But when there is admittedly there is an agreement to sell,
Mm.
and in the written statement we have clearly said, my lord, Lordship will kindly see.
No, now their pair is to
Partition.
yes.
Yes. Now
No. This second pair.
My lord.
Second pair.
Declaring agreement for sale is
Yes.
illegal.
Yes.
Yes, my lord. You're absolutely correct, my lord. Now, if this court ultimately finds that if the agreement to sell is bad and is liable to be declared as void, then we will not get our decree. They will get a partition. Now, the question is, my lord, presently, if at all I am in the collecting rent from my tenant, you are not claiming that, see, it is my property, part of it is mine, and I am entitled to rent, also give me mean profit. Mean profit, they are not asking.
Let notice go at this, is this?
I don't notice will go, but then if this commission is.
No, we will state the order. Heard Mr. D. Mazumdar, learned senior counsel assisted by Mr.
D2.
Learned counsel for the petitioner. This application under Article 227 of the Constitution of India. The petitioners have put to challenge the correctness or otherwise of the order dated
16/8/24.
Order dated 16/8/2024, passed by the learned Civil Judge Senior Division at Golaghat in Mijay case number 37 of 2023. Where is the petition and the documents placed on record? Let notice be issued to the respondent returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. And having considered the submission of Mr. Mazumdar, learned counsel for the petitioner, and also considering the facts and circumstances on the record, the impugned order dated 16/8/2024 is take till returnable date. Leaves the matter after 4 weeks.
If you apply.
Number 40.
Well, in this matter, I am for the appellant, and there is an interim order in the second appeal restraining from raising any construction over the land. Then, my lord, an application has been filed for modification of that order. My submission before lordship is that, my lord, in the meantime, the records have, clause for records have also come. And my lord, hearing this petition for vacating the interim order will as much time as maybe, my lord, the matter may be finally heard.
Finally.
Finally heard.
My lord, sorry, my lord, my senior is now in the court number 17, my lord, for the time being, my lord.
Who is your senior?
P.K. Raichodhi.
Because the LCR has also, my lord, come.
So if the matter is ready for hearing, we will finally hear and dispose of the matter. Where is the objection?
My lord, his instruction, he will appear in this.
Wait for some time then. Let him come.
41. May I please allocate? This matter may come up for admission, my lord, and in the meantime, government side, my lord. may
Admission?
file- Yes, my lord, government side. may file-
Service completed.
Service in this case, all are government.
Official.
Acha.
Actually, my lord, in this case, my lord, may I clarify one fact, my lord, respondent.
So
number-
office note indicates that no step upon respondent number 2 and 5 till date.
Actually, my lord, they are main and important, my lord, respondent number finance and my lord AG. On that particular day, my lord, they were not present just, but their names are all reflected, my lord, and I have given them extra copies also. Must you kindly have a look the call.
Yes, Mr. Pegu, you are representing
Elementary education.
elementary education.
Both my lord, finance and AG both are reflected in the call list. They are main respondent, my lord, and copies are also served, my lord.
Okay, heard Mr. A.M. Bormuya, learned counsel for the petitioner, and also heard Mr. Pegu, learned standing counsel for
Respondent number 136.
136. 136 6 7 8 6 7 8. None appears for the respondent number 2 and 5. Though the name of the
Finance is there.
Finance is come.
what's that? And Mr. Your good name for?
Charlie, your lordship. Yes,
Is Solia for respondent number?
2, lordship.
Respondent number 2. It is submitted at the bar that the service has already been completed and matter may be listed for admission hearing. Accordingly, it is provided that recessal is the matter for admission hearing on after 2 weeks. After 2 weeks.
42. Diploma. Please, your lordship.
Yes.
Received an IA for implement of one respondent, my lord. Personnel B department, my lord.
Yes, you are for?
I am for the elementary education department. Respondent number. IA, human number design.
Respondent number?
4. 4. In IF 4, madam. Main case also 4. Secondary,
So who represents the other respondents?
secondary as well, human number.
7, 2, 3.
3. Secondary also I will refer. And finance also dear. I don't know. Finance 2, 1 and 2.
For finance, I'll be appearing in the I in implicit conclusion.
Personnel B.
Appearing for the finance department in the ILO. Respondent number 1.
1, 2.
I just
6.
For respondent number 1,
1 and 2 lordship, I'll be appearing in the ILO.
1 and 2.
3 and 4 I am B Talukdar.
And madam? Respondent number 6.
PWD.
And for other respondents, this district level committee represented by the deputy commissioner.
Government.
Government. So
No.
Theory by theory
V. Devery was there, lordship. He's there.
Acha. Art Mr. Learned counsel for the applicant. And Mr. Talukdar, learned counsel for the respondent number 3 and 4. And Mr. Soliha, learned counsel for the respondent number 1 and 2. And Madam for respondent number 6. Your good name, please? A. And for the respondent number, other respondents?
B. Devery.
B. Deuri for respondent number?
8, 9.
5, 7, 8, 9, and 10.
5, 7, 8, 9, and 10. 5, 7, 8, 9, and 10. So is there any objection in including the Department of Personnel B?
No, your lordship, not from our.
No. This interlocutory application is preferred for implement of the Department of Personnel B, which indicate capital B, represented by the Commissioner and Secretary to the Government of Assam as respondent number 11 in connected writ petition for proper and effective adjudication of the matter and to secure end of justice. Mr. Loskor, learned counsel for the applicant, submits that implement of the said department is necessary in order to adjudicate the matter effectively, and to secure end of justice. And therefore it is contended to allow this interlocutory application. The learned standing counsel for the respondents submits that they have no objection in the event of allowing this interlocutory application. Whereas having heard the submission of learned advocates of both the parties and also considering the facts and circumstances on the record, this court is of the view that implement of Department of Personnel B, represented by the Commissioner and Secretary to the Government of Assam, is necessary in order to deal with the issues raised in this writ petition. Accordingly, this IA is then allowed. Department of Personnel B, represented by Commissioner and Secretary of the Government of Assam, be implemented as respondent number 11. In terms of above this IA instance disposal, the petitioner shall file amended cause title within 1 week from today. Rest is the list the matter after 2 weeks. After 2 weeks then.
Item 43. This I has been filed for including new respondent contaminants in the connected content application, my lord. Also, may kindly take up paragraph 3 of the I, my lord, page 5. Now, I should indicate one thing, my lord. A mistake has crept in this filing this one with this I, my lord. At serial number 8, my lord, in page number 6. The person named as Srimati Momota Hujai, my lord. Her designation should have been the Director of Secondary Education. Mistakenly, I have written Commissioner and Secretary, my lord. May I be permitted to correct it by hand, my lord? Otherwise, I have to file a new application.
You follow the procedure?
Then, my lord, then may I pray that the person at serial number 6 and 7 may be implemented? Number 8, I'll file a fresh application.
No. Again, the residual is the matter.
So I'm required to file an amendment application, then I may be permitted.
So together we will do this. You file amended petition.
Then, my lord, may I, it will complicate things, my lord. May I pray one thing, my lord? I may be permitted to withdraw this application and file a fresh, my lord.
Okay.
With liberty, my lord.
Heard, Mr.
B. Sharma.
B. Sharma, learned counsel for the applicant. Mr. Sharma submits that he has the instruction to withdraw this application with a liberty to file fresh one. Here is accordingly allowed. This ISS, this was one withdrawal. However, liberty will remain with the applicant to approach this court again by filing appropriate application.
My lord, liberty is granted.
44.
May I please, your lordship? Lordship, I filed for amendment writ proceeding, lordship.
May I please, your lordship? Lordship, I am here in this case, I am appearing for the private respondent number 4. Today only we have received the copy of the I.
Today?
Today.
Acha. What is your submission?
Lordship, I have to go through it, my lord.
Pardon?
I have to go through it, my lord.
Heard, Miss?
M. Sharma.
Learned counsel for the applicant. And also heard Mr.
P. Chaudhary.
P. Chaudhary, learned counsel for respondent number
4.
Respondent number 4 and Mr.
Lordship, I am P. Nayak, lordship, appearing for respondent number 8. Respondent number 3, lordship.
Respondent number 3.
3.
Respondent number 3 for 1 and 2.
I am
Mr. Talukdar for respondent number 1 and 2. Mr. Chaudhary submits that he has received a copy of the application today only and pressed for granting him 1 week time.
After 2 weeks.
No. This is only for implement of one
amendment of the
amendment.
Not implement, my lord. Amendment of the writ petition.
1 week.
Lord.
There is allowed. Recessal is the matter after 1 week.
Date may be
Take a date from
after
him.
20, D. Borgohain will be.
He will give you the date.
45.
Highly obliged.
Public.
This I is for impediment losses. This I is for impediment losses. The applicant has a petitioner in WBC number 2201 losses, 22. The petitioner in the WBC has expired losses. So this wife has paid for impediment losses.
One.
Yes, Mr. Talukdar?
I don't. I'm for 14556. I have no objection. For pension, my lord, bill duty.
And Mr. Devi, you are
I'm for respondent number 3 and 7.
respondent number 3 and 7. Take down.
Finance.
And for 2,
Finance. Yes, only have.
so any objection?
No, my.
No, your lordship.
No objection. Heard Mr.
KD Sharma.
Learned counsel for the applicant, and also heard Mr. Talukdar, learned counsel for the respondent number
1,
1.
4, 5,
1,
and
4,
6.
5, and 6. And Mr. Devi for respondent number
3 and
7.
3 and 7.
3 and 7. Then Mr. Soliha for respondent number 2. Respondent number 2. This interlocutory application under order 22 rule 4 of the Code of Civil Procedure is read with section 151 of the Code of Civil Procedure is preferred by the applicant for substitution as a writ petitioner. For her substitution as a writ petitioner in WPC number 2201 of 2022. The learned counsel for the petitioner, no applicant submits that during the pendency of the WPC number 2201 of 2022, the writ petitioner. What was the name of the writ petitioner?
Writ petitioner, lordship.
Yes. Lokinath Borgohain.
Yes, yes, lordship.
Lokinath Borgohain suffered demise. And that the present applicant, Srimati Tilottama Gogoi Borgohain, is willing to pursue the said writ petition, and therefore it is contended to substitute her name as writ petitioner in the WPC number 2201 of 2022. The learned standing counsel for the respondent departments submits that they have no objection in the event of allowing this interlocutory application. Whereas having heard the submission of learned advocates about the parties and also considering the facts and circumstances on the record, this interlocutory application stands allowed. The name of the applicant be substituted as a writ petitioner in WPC number 2201 of 2022. You are appearing on behalf of?
Applicant, lordship.
Your name is not there in the cause list?
The cause is don't write the worker number. In the worker.
You have file color now.
46.
Your lordship. So this highest is for
Okay.
first time lordship and it is for the condonation of delay of 102 days.
Yes.
So this I is listed for the first time. It is for condonation of delay of 102 days in preferring the connected MFA lordship. So at this stage, lordship notice is negative.
102 days.
102 days, lordship.
Where you have mentioned it?
Lordship in page number 2 of our
Page number?
2.
Page number 2.
Of the I lordship.
2.
Yes, lordship.
Heard, Mr.
SP Sharma lordship.
Learned counsel for the applicant. This application under section 5 of the Indian Limitation Act 1963 is referred by the applicant. New India Insurance Company Limited for condonation of delay of 102 days in filing connected appeal against the judgment and award dated 12/4/2023 passed by the learned Assistant Labor Commissioner Commissioner for Employees Compensation Nagaon in NEC case number 65 of 2012. What is the application and the documents enclosed therewith? Let notice be issued to the respondents returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. List the matter after 4 weeks.
Obliged.
47. Yeah, this IA, my lord, has been filed, my lord, for praying for my lord, directing the registry for early hearing, my lord. In view of my lord, this, I am the respondent number 1 in the RSA, my lord. My lord, he has been
Mr.
suffer, my lord, from heart attack, my lord. This medical document, my lord, I have submitted page 7 to page 15, my lord. My lord, he is, my lord, partially handicapped.
Mr. Sohan, this matter is of 2022.
22 years.
So yes, any objection? No objection. Heard Mr. Sohan, learned counsel for the applicant, and also heard Mr.
M. Das,
learned counsel for the respondent.
appellant lordship, appellant opposite party. I'm for the
This is
appellant.
the appellant in the RSA, my
I am passing the order in IA.
Yes.
In IA, you are the respondent opposite party.
Opposite party.
This application is preferred by the applicant Abhishek Shah for early hearing of the regular second appeal number 170 of 2022. Mr. Sohan, learned counsel for the applicant, submits that the applicant is
age, my lord, 64, my
64.
64, 64.
He is an aged person and he suffered heart attack. Heart attack. And on such count, this application is referred for early hearing and disposal of the regular second appeal number 170 of 2022. The pair being made in this application having not been opposed by the learned counsel for the respondent. This court is inclined to allow the same. It is provided that registrar lists the matter on away.
After puja vacation.
After puja vacation. Okay, after vacation. Take a date for me.
48.
Obliged.
I is seeking proposition of delay of 62 days in filing the first appeal. The first appeal has been filed against an order rejecting my application to set aside the expert degree.
For condonation of delay, 62 days. Okay, let notice go.
Madam.
Heard, Mr.
P. Bharadwaj.
Learned counsel for the applicant. This interlocutory application under Section 5 of the Limitation Act is preferred by the applicant. For condonation of delay of 62 days in filing connected appeal. Against the judgment and order dated.
Madam, this is against the order dated, not the judgment, madam. This is against
Order
the
dated?
Order dated 27th of March 2024.
27 March 2024.
Yes.
Passed in
Miss J case number 331/2023.
Ms. J case number
331
331 of
23, my lord.
2023. Peruse the petition and the grounds mentioned, peruse the application and the grounds mentioned therein, let notice be issued to the respondent returnable in 4 weeks. Step be taken by register post with AD and also by usual process within a week from today. List
Okay.
after 4 weeks.
49.
Please, Your Lordship. Lordship, this application IA is for condemnation of delay only 3 days, Lordship.
Only?
Only 3 days, Lordship. Actually, I've just now checked this main second appeal. The office note is there, but the filing was on 15th of July, Lordship, just on the reopening day of the summer vacation. If that particular day is to be taken into account, Lordship, then the 3 days delay cannot be considered, Lordship. This 3 days, there is no delay with regard to the 3 days which has been mentioned in the office note. So, Lordship, kindly see the main the main second appeal. Because on the reopening day, I filed the second appeal. So that particular period, the summer vacation is to be taken into account for condoning the delay.
Heard Mr. S.P. Sodore, learned counsel for the applicant. This application under section 5 of the Limitation Act is preferred. Limitation Act read with order 41 rule 3 capital A and section 151 of the Code of Civil Procedure is preferred by the applicant for condemnation of delay of 3 days in preferring connected second appeal against the judgment and decree dated 5/3/2024 passed by the learned civil judge senior division Kasar Silisor in title appeal number 02 of 2020. Mr. Sodhori submits that the delay of 3 days is explained in paragraph number
4 and 5, Lordship.
4 and 5 of the application, and further submits that the delay is not intentional, rather it is circumstantial, and therefore it is contended to condemn the same. Having heard the submission of Mr. Sodore, learned counsel for the applicant, I have carefully gone through the statement and environment made in the paragraph number 4 and 5 of the application. He is a disabled person.
Yes, Lordship, he is a disabled person.
It is stated in the paragraph number 4 and 5 that the applicant is a disabled person and he could not come to Guwahati immediately owing to his disability, and he hails from an interior place of Kasar district.
Yes, Lordship.
And taking note of all the facts and circumstances and also the submission of Mr. Sodore, learned counsel for the applicant, this court is of the view that the delay of 3 days in filing the connected second appeal is not intentional, rather it is circumstantial, and the same has properly explained, and the explanation is found to be satisfactory, and therefore delay of 3 days in filing connected second appeal stands condemned in terms of above this IAS disposal. In view of order in IA number so and so, registered as second appeal and list the
Lordship,
same
in the
before the
next
court.
week, which is possible, Lordship. The next week, if the second appeal can be taken up for admission.
No, you go to the registry.
Because this
If
decree-
the registry
execution, they have already
list
filed.
the matter tomorrow, we will take it up, no problem.
In the next week, Lordship, any observation is there, Lordship, then otherwise it will be very difficult. to-
Immediately, except that we cannot direct.
Item 50.
Immediately list the Saita.
May
Yes.
it please your lordship.
Lordship, this is an regular second appeal along with an IA for condonation of delay of 324 days. my lord.
Let notice go at this instance.
Yes, my lord. I have
Heard, Mr. Your good name?
K.R. Bolwar.
Learned counsel for the applicant. This application under section 5 of the limitation Act 1963 is preferred by 3 applicants for condonation of delay of 324 days in preferring a regular second appeal against the judgment and decree. Where it is mentioned?
My lord, judgment decree is 14/7/23. In the first page,
14/7/2023 passed by the learned civil judge senior division Golaghat in title appeal number 2 of 2019. Let notice be issued to the respondent returnable in 4 weeks. Step be taken by registered post with AD and also by usual process. Within a week from today, list the matter after 4 weeks.
my lord, date may be fixed.
Date.
Vacation, after vacation.
My lord, I have one more prayer, my lord. My lord, actually what has happened, till the delay is condoned, other applications are not, my lord, numbered. As such, I have preferred section 151 application. My lord, execution has already been started, my lord. The
No, you file an application before the learned executing court.
my lord, that has already been
So
done.
unless and until we admit the appeal, we are not in a position to pass any order.
My lord can resort to section 151, my lord. it has
Maybe,
powers.
maybe.
My lord, because I'll be prejudiced, my lord. The grounds in the
Okay, we will fix a short date then. But anyway, you have to serve the notice.
till the returnable date, my lord.
Sorry. September, October, 1st of October.
1st October. On 1st October. Primary item 40.
My lord, first, my lord, I'm sorry, but I was in plagues, my lord. The item was called upon, I had to keep my senior friend standing, my lord. My lord, the issue before your lordship, I am for the defendant. My lord, the appellate herein is the plaintiff as a filer suit for saying that we are in position, the defendants are in position, you want a class position. And it
No,
was
Mr. Sodure, counsel for the appellant submits that the matter is ready for hearing.
My lord, only one thing I want to place before your lordship. My lord, I abide by, my lord, what my senior friend has said. Your lordship may look into my application of 1026 of 24. My lord, this is an application under order 39 rule 4. My lord, what with going down my head, my lord, the order of injunction that was passed, it is absolutely barred under the statute and even the Supreme Court judgment. Your lordship may just look into the order passed by this honorable court, my lord. Going down my head, my lord, which is not permissible under the law. Your lordship
That's all
may
right.
just-
We will finally dispose of the matter.
It can be any day, my lord. Next week also I'm ready. As
lord.
per your lordship convenience, my lord, any day.
Yes.
My lord, only thing is this, my lord, my application, your lordship may just look into only that, my lord, I'm placing, my lord, at page 62, your lordship will find. Page 62 is the order passed. It cannot be an order passed under order 39 rule 1 and 2.
Page number 62.
In IA 1026. It cannot be an order.
13/3/2023.
13/3/2023. This order cannot be passed in an injunction application. They are the plaintiff in the suit. Now, this is an application like a order passed in a writ petition. No discussion of a prima facie case, no discussion of balance of convenience, no discussion of after 76 amendment in CPC and in this, well, order 39 rule 1 and 2, no order can be passed in this way, Mal. And Malad, two things, their right title interest and position. Concurrent finding of facts was disapproved by both the trial court and the appellate court. It's a concurrent finding of facts. No right title interest, no position. And I cannot construct or renovate my house where I am in staying. I am in possession.
Yeah, that's all right.
My lord,
uh,
my lord, my lord, your
let
lordship
us, let us fix a very short date.
My lord, I think, your lordship, my lord, my lord, let me fix for hearing for all this document, keeping along this application open, ma'am. If your lordship dispose of this,
No, we are not going to dispose of this application.
my lord, your lordship,
We will hear this application together with the appeal.
my lord, your lordship will fix it.
Okay, as agreed by learned advocates of both the parties, recess shall list the matter on
Can it be on, my lord, 19th September?
Okay, we'll try. Okay.
It was fixed before question number 1. Let it be on 17th, my lord, or any
17.
or any other date.
Then after, then 19th, then my lord be 23rd, 24th.
24th. Okay, 24th. 24th. On that day, an endeavor will be made to dispose of the entire matter along with the IA number 1026/2024 and IA number 547. It is for what purpose?
That was the application filed by them by order 39 rule 1 and 2, injunction application. In that, we have filed an IA.
Okay.
102. For order 39 rule 4. God bless you.
The interim order will continue till the
Till then, interim order pass earlier shall continue.
God bless.
Timing 51.
He is on legs on court number 2. The argument is going on. I'm just praying, my lord, we will take only 10 to 15 minutes. On Wednesday, we'll update, pray for an update. On Wednesday, 10 minutes, 15 minutes will require.
On Wednesday.
I have a submission to make if it pleases your
Yes.
lord. I have not said anything new apart from what I had said in my opening submissions. Only
Yes.
two judgments I have cited.
Yes.
This constant thing of going every day, we are the ones who have to push with the respondent and the appellant continues. Let them give a note. I will give a note tomorrow. So let them also give a note tomorrow.
Okay, you give a note then.
Yes, my lord,
Only 10 to 15 minutes required.
my lord, this is not
Today
being
is Monday, my lord. On Wednesday, I
No,
will-
Mr. Sorma, you can reflect it in your note also.
Yes.
No, certain things are required to be.
My lord, I'm sorry. This
Only
is
because on Wednesday, I will, my lord, pray for update, my lord, it will take only 10 to 15 minutes.
my lord, he's
Not
looking
more.
at his own convenience. My lord, he's kept your lordship waiting and us waiting. My lord,
No,
Mr. Sharma,
Mr. Sorma, I am not closing the door to you.
My lord.
You can effectively reflect it in your written
I
note.
will incorporate, but my lord, at least, my lord, 10 minutes, my lord.
my lord, he's not being fair, my lord, because
On
that means
Wednesday, I'm not asking for 2 PM or like that, my lord, it will be pray for the updation of, it will be around 10:30, 11, whatever may be. Only 10 minutes will require.
this is a part-heard matter. Let him give a note, my lord.
We'll
Every
submit.
day,
for
my lord,
the-
every day they
Only
keep
10
taking
minutes,
time.
people. I just.
He can put it in a note, my
Otherwise, he
lord.
will be here with this argument is going on, in court number 2. So that is the difficult position.
Mr. Sorma, we have accommodated you on many occasions
My lord,
earlier.
only for last occasion, my lord. On Wednesday, I'm not
I'm just not being
postponing the
fair.
matter further.
No, no. You file a written note.
Only to clear.
We have afforded you opportunity today also.
Yes, sir.
As prayed for, we have given you time till 4. Sorry.
Not only on Wednesday, when
Sorry.
first half, my lord.
Sorry. Argument concluded, judgment reserved.
Because we have to respond that, my lord, that submission which has been given, prima
Sorry.
facie, we have admitted that is not a case, my lord.
Any other point or any other matter? Sorry.
My lord.